come to order. Without objection, we will revert to messages from the Senate.
A message from the Senate, Madam Speaker. I hereby announce that the Senate accedes to the request of the House for the appointment of a conference committee on amendments adopted by the Senate to the following House File number 1830. The Senate has appointed as such committee Senators Murphy, Carlson, Mitchell, Westland, and Bolden. Message is signed Thomas S. Bodden, Secretary of the Senate. Madam Speaker, I hereby announce that the Senate accedes to the request of the House for the appointment of a conference committee on amendments adopted by the Senate to the following House File number 1937. The Senate has appointed on such committee Senators Mitchell, Murphy, and Anderson. Madam Speaker, I hereby announce the Senate accedes to the request of the House for the appointment of a conference committee on amendments adopted by the Senate to the following House File number 2073. Senate has appointed as such committee Fateh, Umu Verbatim, and Putnam. Madam Speaker, I hereby announce the Senate accedes to the request of the House for the appointment of a conference committee on amendments adopted by the Senate to the following House File number 2310. The Senate has appointed Senators Herr, France, McEwen, Zhang, and Coleman. Message is signed Thomas S. Bodden, Secretary of the Senate.
Message from the Senate.
Message from the Senate, Madam Speaker. I hereby announce the passage by the Senate of the following House File, herewith returned as amended by the Senate, in which amendments to concurrence of the House is respectfully requested. House File number 2335, an act relating to housing. The message is signed Thomas S. Bodden, Secretary of the Senate. Howard moves that the House refuse to concur in the Senate amendments to House File number 2335, that the Speaker appoint a conference committee of 3 members of the House, and that the House requests that a like committee be appointed by the Senate to confer on the disagreeing votes of the 2 houses.
The member from Hennepin, Representative Howard, to your motion.
Madam Speaker, that is my motion. We have work to do.
All those in favor of the Howard motion, please say aye. Those opposed, please say no. The motion prevails.
Message from the Senate. Madam Speaker, I hereby announce the passage by the Senate of the following House File, herewith returned as amended by the Senate, in which amendments to concurrence of the House is respectfully requested. House File number 2497, an act relating to education finance. The message is signed Thomas S. Bodden, Secretary of the Senate. Joachim moves that the House refuse to concur in the Senate amendments to House File number 2497, that the Speaker appoint a conference committee of 5 members of the House, and that the House requests that a like committee be appointed by the Senate to confer on the disagreeing votes of the 2 houses.
The member from Hennepin, Representative Joachim.
Madam Speaker, that is my motion. We have a lot of work to do.
All those in favor of the Joachim motion, please say aye. Aye. Those opposed, please say no. The motion prevails. The next bill on the calendar for today is Senate File 2909. The clerk will report the bill.
Senate File number 2909, number 3 on the calendar for the day, an act relating to state government, providing for certain judiciary public safety corrections at all, the unofficial engrossment.
I recognize the member from Ramsey, Representative Moller, to explain the bill.
Thank you, Madam Speaker. And before I get into the bill, and I'm going to do my thank yous specifically later on, but I do want to just at the outset here really thank the committee members for some great discussions, great hearings we had this year, especially Lead Novotny. I really enjoyed working with you. And I just want to say the information that we hear in committee, in the Public Safety Committee, is very heavy. We have a lot of very difficult conversations. And I really think all of our members this year were very respectful, were open to hear others' ideas. And everybody really did contribute to make this bill what it is today. There are also some members who have either provisions in this bill, many DFLers. We also have some GOP members who have provisions in this bill, and a couple of you who weren't on committee but I've worked with on bills that ended up in here, Representative O'Neill being one of those in sexual assault issues. Representative Baker and I worked very closely on the fentanyl provisions in this bill, and again, I really appreciate the opportunity that we've had to work together on this. Members, this is a transformational bill for public safety. This bill improves public safety in every corner of our state. We have substantial funding for victim services in this bill. We have the state paying for the cost of sexual assault exams. We have the Missing and Murdered Black Women and Girls Office in this bill. This bill has substantial funding for law enforcement. When we talked to the law enforcement groups at the beginning of this year, they said one of their biggest concerns was recruitment, and we have answered that call with some great provisions in here related to officer recruitment. We also have violent crime reduction supports that the BCA, the money will go to the BCA, and they'll be helping in those local communities where there's crime issues. They've been doing that work. It's good work. We want to expand that work. We have law enforcement mental health treatment in this bill. We have mental health co-responders because not every 911 call needs an officer to arrive, so we have these co-responder models, funding for that in this bill. We have use of force training in this bill. Also, one of the most transformational pieces here is what we do with respect to probation and rehabilitation. We have ongoing investments in probation. This is years of work that have been done by those folks who are delivering probation in our state, and all 87 counties have signed on to the probation formula that we have in this bill. We address current crimes in this bill. As I mentioned already, worked with Representative Baker on the fentanyl crisis, but we also recognize that fentanyl is a public health emergency, and we increase penalties here, but we do more than that in this bill. We also have created a crime of organized retail theft. We've closed some loopholes related to domestic violence. And importantly, we're doing a lot about gun violence in this bill. We have the extreme risk protection order provision in this bill and criminal background checks because we want to make sure that people who shouldn't have access to guns don't have access to guns. We also have juvenile reform in this bill. And we have in Minnesota a broken juvenile system. And we attempt to fix that system, or at least start to fix that system here. We have funding for youth intervention grants. We have Ramsey County therapeutic homes and ongoing support services. And we've got the Office for Restorative Justice and Restorative Justice grants. And Vice Chair Feist did a lot of great work for what's in this bill regarding juvenile reform. We also, importantly, have an investment for violence prevention efforts. This was part of House File 25, which was Representative Frazier's bill, because we know that in order to improve public safety, it is an all-in approach here, and we have to prevent violence also, and we have great funding in here for that that's available to our local communities to get this funding. We also have funding for local emergency management services. And there's just so many great things in the bill, but I know we have a lot of amendments, and I'm excited to get into those tonight. You know, the 4 bills I've had on the floor so far this year have all been unanimous. You know, I'm not expecting a unanimous vote tonight, but there's no reason why this shouldn't be, because this bill really is a great bill for public safety, and I'm looking forward to the discussion. Thank you, Madam Speaker.
The member from Ramsey, Representative Becker-Finn.
Thank you, Madam Speaker. And first, I just want to acknowledge how great it is to work on a bill. A lot of times as a chair, when your omnibus bill is combined with another committee, that's not actually that great of a feeling. But Chair Moller was my vice chair last biennium, and we are sister districts in 40A and 40B, and really proud of not just what is in this bill, but the way that we've done this work together. And it really has been an incredible experience, and it's important to me that we do this work in a good way, and we've done that in both of our committees together, and I think that's really important. Put simply, the judiciary portion of this bill funds our justice system. The courts, public defenders, civil legal services, guardians ad litem, in addition to funding the Department of Human Rights. I know that people often joke and speak negatively about lawyers, but the reality is that everybody in this room has somebody who they care about who at some point in their life has needed the services of a public defender or a legal aid attorney. And in acknowledgement of that, we address that and make that important. Our public defenders are overworked with impossible caseloads and calendars, and over half the people seeking help from statewide from legal aid are turned away because we simply are not putting the resources into these systems. As it stands, how much money and wealth a person has access to greatly impacts their ability to access justice, and none of us should be okay with that. These are often people seeking help getting an order for protection, fighting to keep their families in their homes, trying to access the benefits they're entitled to as veterans or people with disabilities. The lawyers that I'm talking about are public servants first. Like all of us working here, these are people who are choosing to put their work and energy into serving their communities. They could definitely make more money using their skills elsewhere, but they choose public service. Whether it's the law clerk, a judge, a public defender, a paralegal, these are people choosing service. And we need to make it possible for them to continue serving, to keep choosing the pursuit of justice. This bill also includes free access to public court documents. It also increases jury pay from $20 a day to $50 a day. Obviously, $50 a day is still not very much, but as it currently stands, it's only $20 a day, and we are taking steps in the right direction to increase that. We also provide resources to the Department of Human Rights so that they can adequately investigate violations of our civil rights statutes. Finally, we also establish an Office of Appellate Counsel and training to make sure that parents who are in child protection cases have a right. We know they have a right to an attorney, and now we're making sure that those attorneys have the training and those connections are being made so people have that access. Our focus in our committee has always been on helping those who need it most, and this bill does just that. In comparison to the overall bill, the judiciary provisions are relatively small, but they are mighty, and I am proud that we will move this forward tonight. Thank you, members.
There is an amendment at the desk. The clerk will report the amendment.
Moller moves to amend Senate File Number 2909. The first, the unofficial engrossment. The amendment is coded A32.
Representative Moller, to your amendment.
Thank you, Madam Speaker. And members, this is one of those situations where there were dots. We wanted to fill in the dots. We wanted to put in here a clarification that law enforcement who have served for 5 consecutive years are eligible for the student loan reimbursement program. That is my amendment, and I hope you can support it.
Any discussion on the Moller amendment? Seeing none, all those in favor, please say aye. Aye. Those opposed, please say no. The motion prevails. Representative Novotny, I caught your hand going up as I was calling the vote. Representative Novotny.
Representative, we had an amendment to that?
Oh, I'm sorry. Okay. Representative Moller, could you make a motion to reconsider the A32 amendment?
Yes, so moved, Madam Speaker.
Representative Moller moves that we reconsider the A32 amendment. All those in favor, please say aye. Aye. Those opposed, please say no. The motion prevails. The A32 is back in front of us. There's an amendment to the amendment. The clerk will report the amendment.
Whitty moves to amend the Moller amendment to Senate File Number 2909. The unofficial engrossment as amended. The amendment to the amendment is coded A37.
Representative Whitty.
Thank you, Madam Chair. Thank you, Chair Moller. And thank you for highlighting the need to recruitment for officers. The A37 to the A32 amendment is regarding police loans reimbursement. The A37 amendment reduces the length of the time a police officer must serve in good standing from 5 years to 2 years before being eligible to receive grant funding to repay student loans. 5 years seems like a long time to wait to receive a grant to help pay for the student loans after they've come out of school. Representative Novotny had a bill last year, House File 3331, that gave grants to peace officers that had been on the job for at least 1 year. Maybe 1 year isn't long enough, so the amendment attempts to strike a balance by having it be 2 years. Officers are done with their field training program and will be off probation in 1 year. And that will give them an extra year to see if they will fit in the community and with that police department. So I hope you will support the 2-year amendment. Thank you.
On the amendment to the amendment, Representative Moller.
Thank you, Madam Speaker. We consider this a friendly amendment, so members should vote yes. Thank you.
All those in favor of the Whitty amendment, please say aye. Those opposed, please say no. The motion prevails. The amendment is adopted. On the underlying Moller amendment as amended by the Whitty amendment, all those in favor, please say aye. Those opposed, please say no. The motion prevails. The amendment is adopted. There's an amendment at the desk. The clerk will report the amendment.
Kern moves to amend Senate File Number 2909, the unofficial engrossment as amended. The amendment is coded A8.
Representative Curran.
Thank you, Speaker, and thank you, members. First, I just want to give many thanks to Chair Moller, Chair Becker-Finn for the great work that we have in front of us today. And considering, we talked about all the respectful dialogue that we had in our committees and specifically in public safety. So what we have before us tonight in this amendment is a result of several conversations from members across both sides of the aisle, from police chiefs across the state, to what I feel comes to some good language that gets to exactly what people are looking for. And that's to make sure that we want to make sure that our Fourth Amendment rights against undue search and seizure are protected. However, we want to make sure that officers have safe ways to get in when they absolutely need to do it. And so that is the intention with this amendment, and I hope that we will find it friendly. Thank you.
There is an amendment to the amendment. The clerk will report the amendment.
Moller moves to amend the current amendment to Senate File Number 2909, the unofficial engrossment as amended. The amendment to the amendment is coded A40.
Representative Moller.
Thank you, Madam Speaker. And this is just providing some further clarity to the language that was in the A8 amendment, and hope members will support the A40. Thank you.
Further discussion on the amendment to the amendment. Representative Novotny.
Thank you, Speaker Horman. Would the author of the amendment yield for a question?
The author of the amendment to the amendment or the underlying amendment?
The amendment to the amendment.
Representative Moller will yield. Representative Novotny.
Representative Moller, looking at the language, and I'm wondering how the officers applying for this search warrant to be occupied would ensure that it is unoccupied. What guarantee would they have for that being unoccupied, and how do you see that happening? I'm thinking about situations where maybe it's not a residence, a standard single-family residence. Maybe it's a multifamily dwelling or a high-rise. How would they determine that the dwelling is unoccupied?
Representative Moller.
Thank you, Madam Speaker. Well, when a search warrant is applied for, it has to state with specificity the particular area that they're going to be searching. So, right, there might be a multi-unit dwelling, but it has to state specifically which dwelling they're going into. And so what we're trying to get at here is to make sure in those situations where they're doing an unannounced entry that they're unable to do the search at a time when the residence is empty, because that's really the safest time for them to execute a search warrant. So that's what the underlying amendment does, and then we're just offering clarity to that. Thank you.
Representative Novotny.
Thank you, Speaker Hortman. And that goes back to my initial question. How do they ensure that it's unoccupied? How do you prove a negative? And that is my concern with this. And as you said, this could be in multifamily dwellings. How would you know that you have all of the exits covered? How do you know that they're not going out the back when you're watching the front? How do you know that someone hasn't been there for a long time while you're maintaining surveillance on the residence? There's just so many variables in this amendment that I just do not see it's enforceable, or even there's no way that it could be followed without some question. Would Representative Moller yield for one more question?
She will. Representative Novotny.
Representative Moller, if the no-knock warrant were to be granted and it's found to be unoccupied, would that make the warrant then not good and have the evidence suppressed?
Representative Moller.
Thank you, Madam Speaker. This is what they need to do. If you look at the language in the underlying amendment, it also has a reporting requirement when the officers are seeking the no-knock search warrant and what information they have to be able to provide in order to get that. So that's what we're talking about here is when they're applying, they basically have to say to the judge that they have no other alternatives for going in but for house is occupied at all times, and the people that are inside the house are a known danger to them, and so that's why they need to have unannounced entry as a tool available to them.
Representative Novotny.
Thank you, Speaker Horban. Members, I'm going to ask for a roll call on this, and I'm going to encourage the members to vote no. This is, it's just another thing that's going to trap people, and there's no way that you can foresee all the circumstances or that we would be able to ensure during the execution of a search warrant that the residence is not unoccupied. Thank you, Chair.
Representative Novotny requests a roll call. Are there 15 hands? Seeing 15 hands, there will be a roll call. Discussion to the amendment to the amendment. The member from Isanti, Representative Johnson.
Madam Speaker, members, I'm going to request a red vote on this amendment. What this does is make it literally impossible to obtain a no-knock warrant, which is done for the safety of the officer and the safety of the people inside the residence. I've actually have done no-knock search warrants, applied for them, wrote the search warrant, and did the multi-page application that isn't in statute, but what departments use when they're getting ready to do a search warrant. They look at the totality of the situation, the number of people that might be in the room. Are there weapons available? Have they had aggressive actions towards law enforcement and other people in the past? Are they dangerous? Have they committed violent felonies? This is what goes into a no-knock warrant. To make sure that it's done safely, not just for the officers, but the people inside the residence, and also the surrounding area. The last thing law enforcement wants is somebody to get hurt. So with this amendment to the amendment, there's no way law enforcement can ever tell, getting a search warrant 3-4 days ahead of time, if that dwelling is going to be occupied or not. You can't have somebody sit on it 24/7 at each exit. If it's an apartment complex, you have no idea, unless you're sitting in the hallway watching that door, if a neighbor goes into it. This amendment is designed to completely quash no-knock warrants and put our law enforcement officers and the public in more danger. Please vote red.
Discussion. Representative Curran.
Thank you, Speaker. And I just want to say that I have the opposite opinion of this, and the reason is directly in the underlying amendment, we're specifically talking about when an immediate threat of death or injury to officers executing the warrant exists. So that's the basis for what we're talking about here. And with the amendment to the amendment, what we're really trying to get at is that all other options, like Chair Moller said, have been exhausted. This is what we've heard from members who've been concerned about it. This is what we've heard from law enforcement concerned about it is, what if we know the person in there is dangerous? We have information that tells us that. We absolutely need to get in there and exercise and apply for a no-knock warrant in this very specific situation. So I disagree that this is dangerous for anybody. In fact, I think this is completely in favor of public safety. And I'd also just like to say that I find it quite surprising that we have a whole lot of faith in our quite intelligent law enforcement agencies across the state, but all of a sudden we're just totally unsure if a building is unoccupied or not. I find that information to be surprising. I think our law enforcement has quite a bit more training and intelligence than that. And for those reasons, I encourage members to vote yes. Thank you.
The member from Clearwater, Representative Grossell.
Thank you, Madam Speaker and members. What you have in front of you here is the result of trying to fix something that doesn't need to be fixed. There's absolutely nothing wrong with the way no-knock search warrants are applied for and administered. They're not given out like candy. You have to do the investigation. You have to put all the pieces together. You have to have plenty of PC, probable cause, to apply for the search warrant. You have to run it by your supervisor. You have to run it by a judge. Then you have to swear. Swear to that information that you have articulated in your search warrant application. Having written plenty of search warrants in my law enforcement experience, plenty of unannounced no-knock search warrants in my law enforcement experience, having been the first one through that door plenty of times with armed suspects on the other side. A no-knock search warrant is a last resort. Nobody wants to do them. Nobody wants to have to do them. But there's times when they have to be done. Now, to first go and want to get rid of no-knock search warrants was a knee-jerk reaction. It was a knee-jerk reaction. Never should have been repealed or put in the bill as to being repealed. Now we're going to start trying to backpedal and come up with something that, you still make it. I'm glad you put it back in or want to repeal the repealer, but you still make it damn near impossible for police officers to do their jobs safely. You're going to leave them hanging in that fatal funnel, that doorway, way too long. This is not a cure, or this is not a remedy for something that never should have been messed with to begin with. Vote red, please.
Seeing no further discussion, the clerk will take the roll on the amendment to the amendment. The clerk will close the roll. There being 67 ayes and 63 nays, the motion prevails. The amendment to the amendment is adopted. We are on the underlying amendment, but there's an amendment to the amendment. The clerk will report the amendment.
Novotny moves to amend the current amendment to Senate File Number 2909, the unofficial engrossment as amended. The amendment to the amendment is coded A36.
The member from Sherburne, Representative Novotny.
Thank you, Speaker Hortman. And this amendment seeks to take out language that is being added to the no-knock part of the provision. And I refer you to the line. It's to the added language is that you need to knock loud and understandably. That's fine if you're doing a knock warrant. Loud and understandably. I get that. Going down the line, it's where it says, to allow the subject to become alert and able to comply. Members, that is what you call a poison pill. For the few members of the other side of the House that are not lawyers, the Bar Association has, I know there's a couple. The Bar Association has meetings and trainings, I believe they're in August usually, where they get together and they do review of cases and training on how to do their job, and that's fine. But I guarantee you, come August 2023, if those 10 words are added to this search warrant language, that there will be people fighting over how to get into the breakout session where they carefully and with very specific instructions tell the defense attorneys how to get every search warrant thrown out with the language specific as it is, to allow the subject to become alert and able to comply. The conversation will be something like this. Dear client, when you heard the officers knocking on the door, did you hear them knocking loudly and clearly and understandably? No. Did you have time to become alert? Well, what's alert? I might have taken an Ambient the night before. I was a little groggy. Did you have time to get your slippers on, put on your robe, and go unlock the door? Well, no. During committee hearings, Representative Coran, when we asked about this, and we tried to get a number, because I said, we had amendments in committee that said, just give us a number. So we're not taking every search warrant and losing every search warrant based on the fact that the person on the other end has something that they get to articulate. They get to decide if they were alert and had time to comply. It's a poison pill. I'm going to ask for a roll call on this.
Representative Novotny requests a roll call. Seeing 15 hands, there will be a roll call. Representative Novotny.
Thank you, Speaker Hortman. I have a question for Representative Coran. Would you yield?
She will yield. Representative Novotny.
Representative Coran, you talked about talking to different law enforcement agencies. Was there a law enforcement agency that asked you to put that language into the bill?
Representative Curran.
Thank you, Speaker. And Representative Novotny, this didn't come from one specific law enforcement agency. This came from discussions with several groups that we spoke with.
Representative Novotny.
Thank you, Speaker Hortman. Would Representative Coran yield for another question?
She will. Representative Novotny.
During those multiple conversations you had, did even a single law enforcement agency request you to add that language to this bill?
Representative Curran.
Thank you, Speaker. And during all of my conversations with law enforcement, the specific provision or the specific line you're seeking to remove was never brought up as a concern.
Representative Novotny.
Thank you. Thank you for the answer, Representative Coran. And with that, representatives, I ask for a red vote. Actually, I'd like a green vote on my amendment. Thank you.
The member from Isanti, Representative Johnson.
Madam Speaker, members, Representative Botany, thank you for asking that question. That was a question I had planned to ask in committee when we were shut down and only one of our members in committee could actually talk about it, so it was rather frustrating that day. Representative Novotny, I want to thank you for this amendment, because if this wording goes on, it's going to just be another pattern in this public safety bill of doing things for those who commit crime and not to help those who are victims of crimes. With these words in the bill, there's never going to be another search warrant that's going to be applied for by law enforcement, because there's no way they can guarantee that the person if the dwelling is occupied, if the person could actually be alert when the door is busted in. They cannot even be assured they're alert when they answer the door because they could be on some type of narcotics. And that'd be enough to throw the search warrant out. Throw the evidence out in the homicide of maybe Nicholas Inger, who was killed, lived less than a mile from my house, who was killed on the streets of Minneapolis, and it still has not been solved. Or it could have been getting the information on the homicide of the 12-year-old girl jumping on a trampoline that still has not been solved. Law enforcement use search warrants when they have to. They use no-knock search warrants when it's absolutely necessary. And still, a third of them are never used as no-knock. They actually knock on the door because circumstances change in a day or two. But with words like these in this bill, all you're doing is helping the perpetrators. Please vote green on the Novotny amendment.
Discussion on the amendment to the amendment. Representative Curran.
Thank you, Speaker. And members, I appreciate the discussion here. I just want to point out that it is not unlikely for a no-knock warrant currently to be applied for in conjunction with a traditional search warrant. So I just want to point that out, that we're not losing that ability, that we can still go ahead and apply for it in the case that someone might need it, show up and actually exercise a search warrant if you find that the subject happens to be home and maybe they open the door when you get there. Who knows? But what I'm saying is, we do have quite a bit of flexibility with the language that is in front of us today, and it's not going to impede our ability to conduct what we consider a knocker traditional warrant when we're executing that. That's part of our due diligence in public safety, is just making sure that we have all of our bases covered. But specifically to this A36 amendment, no one is saying here that you have to wait for an occupant or subject to come and greet you at a door. What we are going back to is the measure of reasonableness that courts have used for decades, which means that we use facts and circumstances that we have at the time to make the best decision for the situation that we are in. And we had several conversations about the wording of reasonableness, and somehow that was confusing in a committee of public safety. But I would like to point out that if you do a simple search of reasonableness in the statutes in Minnesota, there are in fact over 3,000 references to reasonableness in our statutes. So I don't think that it is unreasonable to offer this language in the underlying amendment. And I also don't think that we don't need to assume that we're actually alerting a suspect. What we're saying is you need to exercise reasonableness based on the facts and circumstances in front of you. And I'll give you a couple of examples there. For example, if you knew that an occupant was a person who is deaf or hard of hearing, it would not be reasonable to simply make loud noise in order to announce your presence. We might be looking at alternative ways to communicate with that person. Also, at the same time, would not be reasonable to expect a hearing or seeing person to be immediately awoken upon flashing lights as something that folks who are deaf and hard of hearing may be more sensitive to. Also just want to say that would not be reasonable if you are going to a dwelling where a person has any kind of physical impairment, whether that's temporary or permanent. It would not be reasonable to think that that person could maybe be alert and compliant depending on what kind of impairment or disability they might have. So again, we're looking at totality of circumstances. We're looking at the facts in front of us. Nobody is trying to get anybody with anything. We are simply trying to protect law enforcement. Thank you.
Discussion. Representative Whitty. And I would just also say, for my benefit tonight, if I pronounce your name wrong, anybody, please feel free to correct me. And if I go to a vote and I'm moving too fast, Don't be afraid to stand up and say, Madam Speaker. You're all blending into the woodwork this evening. Representative Whitty.
Madam Speaker, I appreciate that. Being a former police officer, I've heard a lot worse, so thank you. Representative Kern, would you yield for an answer or question?
She will yield. Representative Whitty.
I appreciate you talking about the reasonableness of it. Did you just say that on a no-knock, it wasn't as important for the offender to be heard, or that they heard that the police were coming in?
Representative Curran.
No, that's not what I said, but for the sake, so that we have understanding, what I intended to say, if I misspoke, was that there will be some cases where facts and circumstances tell us that there may be a better way or another in order to alert a subject of a search warrant or an occupant. So it could be the case that if it's known that someone inside that dwelling, if it is known for a fact the person that we're seeking cannot hear you, then we would maybe have to look at some alternative methods of trying to alert that person. However, it's also reasonable to say that we tried, we made every attempt, we still need to go in, and that still counts as facts and circumstances. That's the circumstances part of it, is if you still need to get in there, you're exercising your warrant, you've done everything you can. As long as you've clearly articulated that in the application for your warrant, then you should be good to go.
Representative Whitty.
Thank you, Madam Speaker. Thank you for that answer. Being a former officer, you know, and I think that's the biggest part of these no-knocks is officers announcing themselves loudly and clearly. I think that's the most important piece of this whole piece. I have spoken to a lot of law enforcement officers and chiefs, and they are not comfortable or want this piece in there. I think we're creating a gray area that are going to have some unintended consequences that could hurt our law enforcement and also offenders and cause a kind of something that we're not expecting after this. So I would say I'm against, obviously, this amendment. Thank you.
On the Novotny amendment to the amendment, any further discussion? Representative Novotny.
Thank you, Speaker Hortman. I think we're reading and putting a lot of interpretation in when it's in black and white on the page. It's in black and white on the page what the amendment is trying to fix in the bill as it currently stands. As I said before, the amendment's a poison pill. We'll talk about the overall bill or the overall amendment to start with, but when we get done here. But I think it comes down to, if we drop down just a little bit, we go down to section 9, it's just in the next paragraph, and I think this is what it all comes down to, is we're adding statutory language that says that this warrant will be thrown out if we don't meet this new high standard or these poison pills that we are building in. Now you wouldn't have had to put this in the language had you not wanted that to be the outcome. That's already part of the law. If a search warrant is thrown out, that's already part of the law, but we're building it into the statutes. And I think that's an indication of what we're trying to do, or what you're trying to do with the bill to start with. Members, please vote green.
The clerk will take the roll on the Novotny amendment to the amendment. The clerk will close the roll. There being 63 ayes and 67 nays, the motion does not prevail. The amendment to the amendment is not adopted. We are on the underlying current amendment as amended by the Moller amendment to the amendment. Discussion. Representative Novotny.
Thank you, Representative, or Speaker Hortman. Representative Curran, you talked about talking to different law enforcement agencies. Did you talk to the three major plank holders, the MPPOA, the Sheriff's Association, or the Chiefs Association on this bill? I'm sorry. Would Representative Curran yield for a question?
She will. Representative Curran.
Thank you, Speaker, and thank you, Representative Novotny. Had they given me a phone call, I would have gladly answered it.
Any further discussion? Representative Novotny.
Thank you, Speaker Hortman. I'd like to point out that Representative Curran's the one that stated that she had talked to multiple groups and that she had done the outreach. This bill was negotiated after a long time and a lot of work after the 2020 special sessions. A lot of work was put into this that all sides agreed to, and that was a public safety bill that I voted for. Then we, as a group, thought that this was the best decision. Now, I am aware that we are trying to amend this bill in response to one incident. I would like to point out to you that the incident that we keep getting brought up for as a reason to fix this law wouldn't be addressed by the amendment that you have. Thank you.
Discussion. Representative Grossell. Further discussion. Representative Curran.
Thank you, Speaker, and again, thank you, members, for the spirited discussion. I encourage members to weigh the information that they've had presented to them. Again, I think that this is very clear what we're trying to do. We're trying to protect police officers in the cases where we know that there's a threat inside and we just can't get around it. And because of that, I encourage members to vote green. Thank you.
The clerk will take the roll on the amendment. All those in favor, please say aye. Those opposed, please say no. The motion prevails. The amendment is adopted. There is an amendment at the desk. The clerk will report the amendment.
Grossell moves to amend Senate File Number 2909, the unofficial engrossment as amended. The amendment is coded A3.
The member from Clearwater, Representative Grossell.
Madam Speaker and House members, again, I stand on this because you're trying to fix something that doesn't need to be fixed. There's absolutely nothing wrong with the way no-knock search warrants or any other search warrants are applied for in this state. There's no reason for it. And if our representative over there on that side cared about the safety of law enforcement officers or the people inside the dwellings,
Point of order, Madam
they
Speaker.
would leave.
Representative Grossell, just want to not go to motives or intentions of other members. Representative Grossell.
Thank you, Madam Speaker. The amendment that you just adopted is not going to protect anybody, law enforcement or civilians or citizens. It is not. Again, this is something that does not need fixing. It's not broken. Read the statute. Read the statute on search warrants, no-knock search warrants, 626.14. Read through it. Everything is in there. Everybody has a piece of this pie. Everybody has responsibility. Every piece of the criminal justice system weighs in on this type of search warrant. Law enforcement, their county attorneys, law enforcement supervisors, judges. My amendment just wipes what you've just done here, what you've just amended here, off of this bill and puts it back to how it was. It doesn't need to be fixed, folks. I just want to ask one question, Madam Speaker. Well, I guess I don't have to ask because I'm not going to pick anybody out. With show of hands, how many people in this chamber have ever executed a no-knock search warrant? That should tell you everything. We have people in here that you're putting, that are bringing bills forward, bringing amendments forward, and bringing bills forward for that matter, that have no idea, that have no background, that have no training in writing and or executing these search warrants. Have some respect for those in the field that have to do this job. Stop putting their lives in danger and stop putting citizens' lives in danger. I ask for a green vote on my amendment.
Discussion on the Grossell amendment. The member from Ramsey, Representative Pinto.
Thank you, Madam Speaker. Members, I think it's important to keep in mind that the St. Paul Police Department, I sometimes will hear from colleagues on the other side of the aisle about concerns about crime here in the cities. Policy was changed close to 10 years ago. St. Paul Police Department does not use no-knock warrants at all. Does not use them. Does not use them. Uses other techniques. We discussed this in committee. I am really grateful to Representative Curran for the amendment that we adopted, because in fact it goes even beyond that. Representative Curran explained the concerns, but I would say, members, if there was no-knock warrant used throughout the state, that'd be the same thing as how it works in St. Paul Police Department. We know that these warrants put officers at risk. They put members of the public at risk, members of the community at risk. That has been shown repeatedly. So we are now adopting in this bill through this amendment an even tighter version of that. So if there is a very narrow circumstance where in fact somebody's going to be present, and Representative Curran explained that, then there are some exceptions. But otherwise, members, that is what puts officers and puts members of the public at risk, is to use those no-knock warrants. They are not used in the state's biggest city. There's no need for them to be used beyond the very narrow circumstances being adopted in the bill. I would urge a no vote. Thank you.
Representative Grossell.
Thank you, Madam Speaker. Members, if you don't accept this amendment, what you're going to be doing is you're engraving into statute the idea that a judge sitting behind a desk can know what constitutes an immediate threat of death or injury to the officers better than the officer who's working the investigation, who is under that threat of death or injury. Again, accepting the previous amendment, you've put both the citizens and the officers in danger. Other cities can do what they want to, but the rest of the state, you don't cover everything with the same under one blanket, folks. I'm asking for a green vote on my amendment.
Representative Novotny.
Thank you, Speaker Hortman. I was going to ask for a roll call.
Representative Novotny requests a roll call. Seeing 15 hands, there will be a roll call. Representative Novotny.
Thank you, and thank you, Representative Grossell, for bringing this amendment forward. As I said previously, this is the current laws regarding search warrants and applications for no-knock search warrants. They work. I understand that St. Paul has decided that it's just not worth the fight. They'll do things different. St. Paul's got a lot different situation than someone doing a search warrant in Otter Tail County, for example. The logistics, or Pope County, or off the top of my head, I know we just had an officer shot standing outside a door on a knock and announce warrant just last week. It is dangerous. Off the top of my head, I can tell you twice that I was able to get to a person that we knew would be armed, and both times that person went for the gun, and both times I was able to intercede before he was able to draw the weapon down on us. And you're going to take that away. In a situation that we were fairly certain would happen, and it did. And we're going to take that away. And I think the chilling effect is going to be as Representative Johnson said that there just won't be any search warrants. I don't know what the desired response is. I don't know if you're going to email them or send them a certified mail that a search warrant's coming. Maybe just ask them to turn their evidence in and incriminate themselves. Members, please vote for Representative Grossel's amendment. Thank you.
The member from Pope, Representative Anderson.
Thank you, Madam Speaker and members. It was just this last Saturday we laid to rest a Pope County deputy after an incident that occurred in our county about a week ago. And I don't know the details of what happened. They haven't released a lot of details yet. 3 officers entered a residence in an apartment. Shots were fired, and this officer was killed. And at the funeral, there were an estimated between 4,000 and 5,000 people that showed up to show their respects to the officer. I saw license plates from vehicles as far away as Texas. I talked to a couple of officers who had come from New York City to pay their respects to the slain officer. And talking to the people that are here talking tonight, the retired people in law enforcement, they know what it's like. They know what the situations that people face, and these are life and death situations. And the intentions, I'm sure, are good, but again, we have to put the safety of officers right up there. I mean, they deal with these things every day, and we saw the results of what can happen. And to have any talk of lessening the protections for officers at a time like this just doesn't sit well with me as we try to cope with the tragedy that happened last week. And we need to show support for these people, and I would encourage a green vote on the amendment. Thank you, Madam Speaker.
Representative Curran.
Thank you, Speaker, and thank you again, members, for the discussion. And I agree, we need to protect our officers. And what's happened so far this year is tragic. We need to have a response to that. I do believe that some of the work that we're doing here in this bill, and specifically with this provision, do address that issue. And I say that because the officers who've been shot or have given their lives in the line of duty for us have been doing so in the regular course and scope of work. So we're talking about domestic assault calls in particular, with the recent death of the Pope County deputy. We're talking about arrest warrants, like the Officer Sheik, who was shot in my district, unfortunately. And so, yes, these are things that happen that are dangerous. This is a dangerous profession. Yes, I did serve in uniform, and yes, I have been in dangerous situations. So I do have some perspective here. You know, it's not often that usually you hear somebody stand up and say they're a lawyer, but I'm standing up and saying, yes, I was a police officer, and it takes a whole lot to put on that uniform every day, as those of you who've put it on know. Every single day, you don't know if you're coming home back to your family. That's a real fear. I share that with you. I have shared that with you. What we are trying to do is limit that from happening, because too often we have people going into situations and getting hurt or killed when it is absolutely preventable. And we need to take serious pause when we're considering these actions that can be so deadly. And not only deadly, but in some cases entirely unconstitutional. And I don't know that anyone in this body wants our constitutional rights infringed, and I know we're going to talk about that some more too, but when we're talking about life and death situations, as we are, we need to consider the rights of people inside this place that we're trying to get into as well. So this is a balance. This is a balance that we strike between individual constitutional rights, safety for occupants who may be the subject of a warrant, and yes, safety of law enforcement. And for those reasons, I feel like we have some great language in front of us. I do not want this stripped from the bill. It makes this bill so much better. So I encourage everyone to vote no to strip this. Thank you.
Representative Moller.
Thank you, Madam Speaker. And I just want to point out that some of the situations that have been talked about in committee and on the floor today aren't impacted by this bill. When an officer is responding to a 911 call, that's an exigent circumstances. What our bill is getting at is search warrants for evidence. And we have in your packets here a letter from the National Tactical Officers Associations, and that says this: agencies initially use no-knock search warrants to protect the officer from violence and preserve evidence for the prosecution. Though the intent sounds reasonable and is noble in theory, the practice is flawed at its very core. When considering the priority of safety and life, it is difficult at best to justify or defend no-knock warrant service. Lessons learned over many years and our desire not to repeat our past mistakes are the foundation for our position. So our bill actually makes law enforcement safer. It makes the people inside safer. And for that reason, members, I suggest a no vote on the Grossell Amendment.
Seeing no further discussion, the clerk will take the roll on the amendment. The clerk will close the roll. There being 63 ayes and 67 nays, the motion does not prevail. The amendment is not adopted. There's an amendment at the desk. The clerk will report the amendment.
Nash moves to amend Senate File Number 2909, the unofficial engrossment as amended. The amendment is coded A2.
The member from Carver, Representative Nash.
Thank you, Madam Speaker. Representative Moller, I like this provision that I'm trying to amend this into, and I'll tell you why. So I know that there are a good number of school districts around the state that are making a decision to not fund security based on some pressures that they've had. And I have a couple of those in my district, but I think that we've seen, based in recent news and some of my professional experience, that security is not just always physical security, that cybersecurity is an important aspect of this. So if you can get somebody who can defeat electronic systems, they can take down physical barriers to access the school. And I think as one of the two folks that you're going to fund in your $300,000 appropriation, if we could maybe ask for one of them to have some cybersecurity background, I think what that does is it also alleviates some of the pressures that school districts are going through, because having worked in cybersecurity, when we offer our services to school districts, sometimes they say, wow, that's really expensive, and we're going to make a decision not to. I think that if we can maybe require or ask of the people to have some background in cybersecurity, they can lend some of that expertise to schools to say, here are some of the best practices that you should be going down. And I would hope that you view this as a friendly amendment, because it is certainly offered in that vein. This is not a Jim Nash got you amendment. That's coming later. But this is actually offered in the absolute best effort to make your bill a little bit better, because if you're going to spend that money to put those two new people into the school safety center, I think that it would be very helpful to the school districts around the state and to the children and the people who work there to have somebody with a background in cybersecurity.
Representative Moller.
Thank you, Madam Speaker, and thank you, Representative Nash. We do view this as a friendly amendment. It does make logical sense to us, so I would recommend members vote yes.
Representative Nash.
Well, Madam Speaker, it makes my heart soar like a hawk that the DFL says Jim Nash amendment makes logical sense. I appreciate that. Members, I do appreciate the conversation on this, and I appreciate you accepting this. Thank you.
All those in favor of the Nash amendment, please say aye. Those opposed, please say no. The motion prevails. The amendment is adopted. There is an amendment at the desk. The clerk will report the amendment.
Scott moves to amend Senate File Number 2909, the unofficial engrossment as amended. The amendment is coded A11.
The member from Anoka, Representative Scott.
Thank you, Speaker Hortman. Members, my amendment requires that out of the funding for the Guardian Ad Litem Board, that they use $225,000 of that fund to recruit and train volunteer guardians ad litem. This bill was heard a couple of years ago. Oh, my other amendment? Oh, that's the 11. I apologize. One moment, please, Madam Speaker. All right. Thank you, Madam Speaker. My apologies, everybody. And now you know my secret opening for my next amendment. But the A11, folks, this bill is said to be, the overall bill is said to be the get out of jail free card. But this amendment puts away into jail the perpetrators that need to go there. The A11 amendment increases the penalty for intentionally transferring a firearm to a person, takes it from a felony, or takes it to a felony from a gross misdemeanor if the person who does the transfer knows or has reason to know that the transferee is ineligible from possessing a firearm. During his time as Hennepin County Attorney, Mike Freeman admitted that his office had not prosecuted a single straw purchaser in cases where prohibited persons committed crimes involving firearms. I lifted this language, the has reason to know, from Representative Pinto's bill that puts additional restrictions on the transfer of firearms. His bill increases the current penalty on a person who makes a false statement in order to obtain a transferee permit, knowingly or having a reason to know the statement is false, from a gross misdemeanor to a felony. If it should be a felony to make a false statement to obtain a transferee permit, then it should also be a felony to transfer a firearm to an ineligible person. This amendment comes from a bill I carried. I had a fiscal note run a couple of years ago. The cost is $0. I have a copy of that fiscal note here as well, if anyone cares to see it. Members, we need to focus our efforts on the criminals who exchange firearms illegally to commit acts of violence instead of turning law-abiding Minnesotans into criminals. Please vote green. And Madam Chair, I would request a roll call.
Seeing 50 hands, roll call will be requested. The member from Ramsey, Representative Moller.
Thank you, Madam Speaker. And first, I just want to say that there's some inaccurate information that's being portrayed about the Hennepin County Attorney's statements in 2019. Mike Freeman explained that Hennepin County doesn't prosecute these cases because the county doesn't have jurisdiction for gross misdemeanor cases. Those are city cases. The county does felony cases. And I can assure you, as a prosecutor at the county, I've certainly prosecuted numerous gun cases over my years. However, I will say that I actually like what you're doing here with this amendment, and I'm going to recommend a yes vote on this, because I think that this amendment works really well with what we're doing in the bill with respect to the criminal background checks. So for that reason, I'd recommend a yes vote.
Further discussion, Representative Scott.
Thank you, Madam Speaker, and thank you, Representative Moller. I will remove the request for a roll call, and I encourage members to vote yes. Thank you.
Representative Scott withdraws the request for a roll call. All those in favor of the amendment, please say aye. Aye. Those opposed, please say no. The motion prevails. The amendment is adopted. There's an amendment at the desk. The clerk will report the amendment.
Scott moves to amend Senate File Number 2909, the unofficial engrossment as amended. The amendment is coded A4.
Representative Scott.
Thank you, Madam Speaker. And well, we'll do the first part over again to this amendment. We'll have a little rerun here. But what my amendment does says that, hey, Guardian Ad Litem Board, of the funding that you're receiving this year, you have to use $225,000 each year to recruit volunteers and train volunteer guardians ad litem. Members, this is a program that's been in the state of Minnesota for 40 years. 40 years we've been using these volunteers, and they are a vital resource to kids that are in need of having a trusted adult walk them through, a trained trusted adult walk them through a very, very difficult time. And members, I think being passed out right now is a testimony of Grace Jones, who testified March 29th of 2022 in the Judiciary Committee. And she came in and she was flustered. She had forgotten her written testimony at home. So she did all this off the cuff. And so I want members, I want to draw attention to a couple of the things that she said. She said, "Good afternoon, my name is Grace Jones. I've been a volunteer guardian ad litem for Hennepin County for the last 17 years. I was introduced to the program 17 years ago when my two great nephews were taken into child protection. At that time, there was a social worker who told me that it was not normal for kids to play house. I think it was boys to play house in that case, it's two nephews. So when I decided to start my education at Inver Hills Community College, where I've been employed for 20 years, I joined the Human Services program. I was directed to the Guardian Ad Litem program, which agreed to take me on in an internship 17 years prior." She states in here that her husband was a police officer and told her that she shouldn't do this, but she went back and she has been a volunteer for 17 years. She says in that third paragraph down, "I've advocated for over 130 abused and neglected kids. I've assisted those kids with being reunited with some of their biological parents and families, some of whom have been placed in permanent foster homes. But as a guardian ad litem and as a volunteer guardian ad litem, it was such an honor to be able to advocate for these kids in these situations. I've seen so many kids in the courtroom with nobody there to support them. I've seen kids going through this system, and the judges change the attorneys, and the judges change the attorneys, change the social workers." I'm not sure what that sentence is exactly, but we stay steady in the kids' lives. Oh, I know what she was saying, that the attorneys will change, the social workers will change, but the guardian ad litem stays with them. She says, "As a recovering addict of 28 years of crack cocaine, I can relate with the parents that are dealing with drugs because I'm able to tell them my story. And I'm able to say to them, I'm no better than you, look at me. If I can do it, you can do it." Members, this is a really valuable program, and we need to continue to support these folks. Just yesterday, 2 days ago, I was called out into the hallway, as we often are, by different lobbyists or groups that want to meet with us. And I was called out there by the Association of Family and Conciliation Courts, the Minnesota chapter. There's about half a dozen of those folks there, and I don't know if any of the rest of you had an opportunity to visit with them, but I did. And I asked them about the Guardian Ad Litem program, and they said, definitely we need the full-time folks and we need the volunteers. Both play a really significant role in our system for our kids. So members, I'm going to ask for a green vote on this funding. Thank you.
The member from Ramsey, Representative Becker-Finn.
Thank you, Madam Speaker. Members, I'm going to ask you to vote no on this amendment, and I'll explain why. We can certainly appreciate what volunteers in this program have done, but the reality is that it is best for children if professionals fill this role. I'm going to share the Minnesota Guardian Ad Litem Board specifically has addressed this. The board unequivocally supports the unanimous management position that the role of a guardian ad litem as defined in rule and statute is no longer a volunteer role. Management will continue to train and support the current pool of volunteers, but is going to move away from a volunteer model through natural attrition. The role of a guardian ad litem is that of a professional, requiring specialized training and a high level of accountability given the access to children and families at their most vulnerable, as well as access to confidential information. No other party to a juvenile court case serves in a volunteer capacity like this. So again, we can appreciate the volunteers who've been doing this work. The Guardian Ad Litem Board will continue to support the folks like Grace who've been doing this for years, but they're no longer going to continue to recruit people for this. Further, we certainly don't want to be defunding the work of Guardian Ad Litem professionals statewide to fund the supervision and administration of a volunteer program that only serves 2 metro judicial districts. So again, members, going to ask you to vote no on this amendment.
Representative Johnson.
Madam Speaker, members, I stand in support of the Scott Amendment. I've worked with many guardian ad litems in my career in law enforcement because I've had the unfortunate situation where I've had to remove children from their parents. Now, the guardian ad litems is a great program. It was started by the volunteers and continued for many, many decades. It's unfortunate that the so-called professionals, the ones that are paid, are now telling this body that we don't want the volunteers anymore. It's unconscionable. The volunteers is what made that program. I've worked with both volunteer and paid guardian ad litems. I'll take that volunteer any day. Because they're there for the kids, not for the paycheck, but for the kids. They have a passion for the kids, to do what's best for the kids. Whenever they can, get them back to their families, or if it's a situation that it's too dangerous for them, to make sure that the kids are safe. There's no better person for the guardian ad litems than the volunteers. I'll take them any day. Thank you, Representative Scott, for this amendment. Please vote green.
Any further discussion? Representative Scott.
Thank you, Speaker Hortman. And members, I'd like to request a roll call.
Representative Scott requests a roll call. Seeing 15 hands, there will be a roll call. Representative Scott.
Thank you, Madam Speaker. And members, 49 other states have a volunteer at guardian ad litem program, 31 of which are funded by their state. Why would we want to be an outlier on this? I don't understand it. I don't understand it. Please vote green.
Seeing no further discussion, the clerk will take the roll on the amendment. The clerk will close the roll. There being 60 ayes and 70 nays, the motion does not prevail. The amendment is not adopted. There is an amendment at the desk. The clerk will report the amendment.
Becker moves to amend Senate File Number 2909, the unofficial engrossment as amended. The amendment is coded A25.
The member from Traverse, Representative Becker.
Yes, Madam Speaker. First of all, I would like to request a roll call.
Representative Becker requests a roll call. Seeing 15 hands, there will be a roll call. Representative Becker.
Thank you, Madam Speaker. And members, first of all, the A25 amendment redirects funds from unaccountable nonprofit organizations and violence interrupters. And what it does is instead it gives local governments the major resource. So when you dial 911, you get the correct help. All of us, when you dial 911, you don't want to go, whoops, it didn't go through, okay? It's not like you don't have like a scenario with the Verizon, did you hear me now? You don't want that to work with communications with EMS. So I've been amazed the last month how many agencies have reached out to me on saying how vitally important this is. So let me just go through a couple examples. These are personal first-hand examples. Now before the Armor radio, we had a situation that this is in the late 90s, early 2000. If you needed to communicate, ambulance needed to communicate with police or fire, we had to go through dispatch. So one Saturday night, moi, that's me, of course, in French, was on a run. If you didn't know French, okay, I'm language education here tonight. But on the serious note, we had a run. I was on the west side of the house, okay? The police officers had their guns drawn on the east side of the house. Did not know that. Guess who discovered that the people inside did not have guns? Me. I kid you not. I did not know it was that type of situation. This was before we had armor. I'm glad they did not have guns. Let me share with you, the police chief did not have kind words with me that night, and quite frankly, my wife agreed with him. And that shows the lack of communication. That shows the lack of communication. Let's use a different scenario. Representative Anderson talked about Deputy Owens. That scenario had multiple agencies report that Saturday evening on April 15th. They were able to communicate together. They were able to communicate together. Let me use another scenario. Now, I wasn't directly involved with it because I stayed back in our call area to cover a call. But in the summer of 2021, the city of Clinton and the Clinton elevator had a huge grain fire. Huge. If anybody knows, grain elevators are tall. When they burn, ashes fly around. What does that mean? That can get in on other homes and can literally take a whole community down. Burn a whole community down. They had 21 agencies on bringing water, ambulance, police, sheriff. They blocked off Highway 75 because that's where they pulled the excess water, because guess what? When you're putting a fire out for an elevator, that water tower does not have enough water, okay? That's like spitting in the wind when you have a fire that big, okay? They were able to communicate. And then another one that I'll give, this is after 9/11. This was a Friday morning, 7 o'clock. I was down at my brother's place. Pager goes off. We were called for a mutual aid for a head-on collision on the South Dakota side of the border. It was not our call area, but there was multiple casualties, and we were able to communicate. The challenge that we have right now is in our communities, small towns and so forth, and agencies, we do not have proper communications. We have radios that are 10 plus years old. Easily. Sunday morning, I sent out a couple texts, unfortunately during church, because I got this bright idea of asking some of the agencies how many radios they had not working, or 10 years or older. Boom, boom, boom. I got it right back right away. So it's a problem, and communication is so important because we're talking about, in a lot of times, it's life and death. Not always, but a lot of times it is. And also, it's not necessarily like I've been on several domestic dispute runs. That communication can calm down a situation. If we know what police is doing, if it's a deputy from Traverse County, or if we're in Big Stone County, or we're working with the tribal police in Roberts County, South Dakota, that communication can calm down a situation. So it makes it safe for us, the EMTs. It makes it safe for the individuals there. I do appreciate the chair allocating $1 million, but quite frankly, folks, Big Stone County needs $900,000 of radios to update their radios. We heard in committee, the fire chief from Ortonville, 2 weeks before that, had a radio that quit working. I've been working with stakeholders a long time with this, and to replace the radios across the state, so when your family, or your children or grandchildren on both sides of the aisle needs help, agencies communicate. We're talking about $250 million. So my amendment here takes $100 million from unaccountable nonprofit organizations and violence interrupters and gives it to communications to people who need it. So if we have to call in a helicopter on scene, we can communicate with them. Instead of running to the ambulance, hop in, we can do it with our handheld radios. So I would ask for a green vote. Thank you, Madam Madam Speaker and members.
Representative Moller.
Thank you, Madam Speaker. I'm going to recommend a no vote on this one. We do have funding for the armor systems here in our bill at $2 million. The money that is being requested is defunding violence prevention efforts, throughout our state. And contrary to what was said about the provision that it's taking money from, I'll just remind you that that involves grants to community-based nonprofits or local governments. And the nonprofits that apply must have support demonstrated by partnership with their local governments. That funding also includes funding for victims for services. And those victim services are throughout our entire state. We have those victim services programs. They're eligible for the funding that is going to be defunded if you vote yes for this amendment. In addition, we have programs that provide services to individuals and families harmed by gun violence. Again, if you're voting for the amendment, it means you're taking away funding for those critical resources. So for that, I'm going to recommend a no vote. Thank you.
Any further discussion? Representative Becker.
Thank you, Madam Speaker and Chair. And we have to set priorities. That is exactly why this amendment reallocates those funds. When you dial 911, if it's for your child, your grandchildren, yourself, we need to communicate. I'm not saying that's not important. It's just not a priority. I've never had agencies come around and says they need violent interrupters. They want to be able to communicate. They want the resources there. That is so important. Look at the bridge on 35W, I think that was. They needed to communicate. If we don't communicate, we can't bring in other people afterwards. This is so vitally important. I don't know how I can get this across. I've been on those situations. My first example, I did not have the proper communication. I am glad that I am still here today. When you have officers that have their guns drawn because they think the person inside is armed and dangerous, and walks in and says, okay, we're okay, that's not smart, okay? And that's because of lack of communication. Our officers put themselves at risk. Fire. I haven't got into the fire because I'm so focused on EMS, as you're all well aware of, and so forth. But fire needs that communication. So I respect your comments, Madam Chair, but this is a priority. Public safety. That's what the bill is, public safety. And if we don't provide safety and proper communication, we're down the creek without a paddle. Thank you, members. Vote green, please.
The clerk will take the roll on the amendment. The clerk will close the roll. There being 60 ayes and 70 nays, the motion does not prevail. The amendment is not adopted. There is an amendment at the desk. The clerk will report the amendment.
Niska moves to amend Senate File Number 2909, the unofficial engrossment as amended. The amendment is coded A6.
The member from Anoka, Representative Niska.
Thank you, Madam Speaker and members. Within this public safety omnibus bill, tucked somewhere in its many hundreds of pages, is a pretty troubling provision to me that creates a registry of biased incidents that appears to me to basically be a government surveillance of our speech. And this was coming from, I think, a bill originally introduced by Representative Vang. I'm hoping I'll be able to talk to her about that in a bit. But what I found interesting about this bill is that there's already a bias crimes registry statute that requires police officers to report crimes that are motivated by bias and send that information to the BCA. The Bureau of Criminal Apprehension then files an annual report that can be used by us or by the Human Rights Department to understand what crimes are being done motivated by bias. What this bill does is goes beyond that, and it sweeps in incidents that are not criminal, but instead that would just be purely speech. We did hear in committee from the Human Rights Department that they wanted to deal with concerns from the community about bias and hate incidents where people did not want to report those incidents to law enforcement. So my amendment is going to try to alleviate that concern, but also to deal with the concern that this provision sweeps far too broadly and includes incidents that are purely speech and not criminal conduct. I don't believe we should have government bureaucrats deciding what is and what is not a speech incident that should be put in some government surveillance registry and looked at by the government. And so I was hoping if Representative Vang would yield for a question.
Representative who?
Representative Vang.
She is not on the floor at the moment. Representative Niska.
Would Chair Becker-Finn?
She is on the floor. Let me just see if she would yield for a minute. Would Representative Vang yield to a question? She will yield. Representative Niska.
Thank you, Madam Speaker. And Representative Vang, it's my understanding, and you can correct me if I'm wrong, that you're the author of the provision on page 50 and 51 in this bill that creates a registry within the Human Rights Department for bias incidents. And as I mentioned, we already have a registry about crimes of bias. And so it's my understanding that this goes beyond just criminal incidents. So could you help us understand what types of non-criminal incidents would this intend to also include in this bias registry at the Department of Human Rights?
Representative Vang from Representative Listagard's seat.
Thank you, Madam Speaker, and thank you, Representative Niska, for the question. So the provisions in this bill will basically looks at, we all know that since the pandemic, we have seen a rise in anti-Asian sentiment and hate. We've heard anecdotal evidence and social media stories from bystanders and from those who've been attacked by simply being Asian, being accosted at the grocery store, being harassed, abused. And so sometimes not all incidents are criminal. And so what this bill looks at is making sure that we have an accurate reporting of what is actually happening to communities experiencing hateful incidents in their community.
Representative Niska.
Thank you, Madam Speaker, and thank you, Representative Vang. This does really get at my concern, however, and I understand that sometimes harassment does cross the line into something that the government can and should look at and deal with, and I think that we should do that. I am, however, concerned about certain ways in which, as we discussed in the Judiciary Committee, the Department of Human Rights would have discretion about what is and what is not something that's motivated by bias that goes into the registry. And so I did have a few questions about that if Representative Vang would yield for another question.
She will yield. Representative Niska.
Thank you, Madam Speaker, and Representative Vang. If a Minnesotan writes an article claiming or arguing that COVID-19 is a Chinese bioweapon that leaked from a lab in Wuhan, and someone reports that article to the Department of Human Rights, is that something that the Department of Human Rights should put in their bias registry under your bill?
Representative Vang.
Thank you, Madam Speaker. Representative Niska, not all incidents are considered, I guess, violent or criminal, as I said before. And so this clearly, with the rhetoric that we have seen since the pandemic and regarding accusing Asians of bringing in the coronavirus, that is bias motivated. And so that can be considered a bias incident.
Representative Niska.
Thank you, Madam Speaker. I think I heard yes to that, which is very troubling to me, that someone making a factual argument along those lines, I think is something that's within political discourse would be included in the Department of Human Rights database. Let me ask you another question, though, if Representative Vang would yield.
She will yield. Representative Niska.
Thank you, Madam Speaker. And Representative Vang, if a Minnesotan is wearing a T-shirt that says "I love J.K. Rowling" and someone sees that and reports them to the Minnesota Department of Human Rights as an example of gender identity or gender expression bias, is that something that the Minnesota Department of Human Rights should put in this bias database?
Representative Vang.
Thank you, Madam Speaker and Representative Niska. I think this question will best be answered by the lawyers. I'm not a lawyer myself. I think in the language of the provision, we have looked at the language to make sure that a substantial part of any incident has to be relating to bias and hate and motivated. And so I will, I'm not going to say a yes or no to that question. It is really up to the those investigating to decide whether there is substances on bias and hate incidents.
Representative Niska.
Thank you, Madam Speaker. And that's a pretty shocking answer that you aren't able to say that someone wearing a J.K. Rowling T-shirt being reported to the Minnesota Department of Human Rights for gender identity or gender expression bias would not, under your bill, that the Department of Human Rights would not put that into their bias database. How about another example, if Representative Vang will yield?
She will yield. Representative Niska.
Thank you, Madam Speaker and Representative Vang. And again, I'm asking you not as a lawyer, but as the author of this language and to understand what your intent is about how the Minnesota Department of Human Rights will exercise the discretion that you're giving them in your bill. If a Minnesotan argues that there are two specific Christian colleges that should be excluded from the PSEO program, and someone hears that and reports that argument to the Minnesota Department of Human Rights as a bias incident motivated by religion, is that something that the Minnesota Department of Human Rights should include or exclude from their biased registry?
Representative Vang.
Thank you, Madam Speaker and Representative Niska. I think faith and religion is part of a protected class, and that is something that the Department of Human Rights can look at.
Representative Niska.
Thank you, Madam Speaker. That sounded like a yes to me. That's an opinion that I very strongly disagree with, but it is absolutely not an opinion that the Minnesota Department of Human Rights should be putting in a speech registry. How about this, if another example, if Representative Vang will yield?
She will yield. Representative Niska.
Thank you, Madam Speaker. If a Minnesotan is in a video and says that they believe that, in fact, white kids should feel bad about American history, and a parent sees that and reports that to the Minnesota Department of Human Rights as an example of race bias, is that something that should go into the bias registry, or should the Department of Human Rights set that aside?
Representative Vang.
Thank you, Madam Speaker. Representative Niska, as you coming from a marginalized community, I think it might be hard for you to understand what it's like to feel othered and like an outcast, and to feel
Madam Speaker,
like
point of order.
Representative Niska.
Madam Speaker, personalities.
Representative Niska, she's nowhere close to that. Representative Vang, you have the floor.
Thank you, Madam Speaker. As I said, coming from a community that's been historically marginalized, abused, and have a history of persecution, I think it's hard to describe the feeling of what it means to be unsafe to someone who has half the privilege of being safe. And so I would just leave it at—
Madam Speaker, point of order.
Representative New Brindley, state your point of order.
Under 1.24, we are not allowed to engage in personalities or motives on the floor.
Representatives Niska and New Brindley, Representative Vang is speaking about her personal experience.
And she is assuming that other members do not have that experience.
Representative New Brindley, you are out of order. Representative Vang, you have the floor.
Thank you, Madam Speaker. I'll just keep this brief. I will just say that as a community member who has seen in the past previous years the rise of rise of hate incidents against me and my own members of the community. I think it's very important that we continue to make sure that hate has no place in anywhere in Minnesota, in any corner of the state. So I will just leave it at that, and I will not yield for further questions. Thank you, Madam Speaker.
Representative Niska.
Thank you, Madam Speaker and members. And Madam Speaker, Representative Vang was speaking about me personally. Perhaps you didn't hear, but she did. Members, what we heard from Representative Vang, however, is 1984. It is a speech registry in which the Minnesota Department of Human Rights, unelected bureaucrats at the Department of Human Rights, are going to collect certain political opinions that they do and do not agree with. And if government employees can try to silence and threaten a powerful member of the Capitol Press Corps, think about what they're going to do to people who have political opinions that they don't like, who they assume have had certain experiences and have not had certain experiences, who they assume are members of a powerful class or not. That is exactly what the bias registry in this bill does, and the fix to that is really pretty simple, which is we're going to make sure that when we talk about bias, when we look at trying to collect information about bias, that we look at collecting crimes about bias, which is what current law does, and what my amendment tries to enhance by making sure that the Department of Human Rights certainly can take information from community groups and can pass it to the Bureau of Criminal Apprehension if it involves a criminal incident. But the Minnesota Department of Human Rights does not get to have surveillance about political views that they do and do not disagree with. The fact of the matter is, Representative Vang and the Department of Human Rights are going to have the same trouble distinguishing what is a legitimate and what is not a legitimate view when someone comes to them and says that they are being targeted by bias. There are people who, folks on that side of the aisle, don't think are oppressed or have a reason to feel oppressed, but they do feel threatened. And they will go to the Minnesota Department of Human Rights if we leave that door open. And this is not going to just go one way. If you assume that you are always going to control the Minnesota Department of Human Rights, you're always going to control the government, then yes, it's very easy to think about the government surveilling your political opponents. But we should be very, very careful about government surveillance and government collection of data about speech. The amendment is very simple. The amendment is very simple. It's a very easy fix. It makes sure that what we're looking at, collecting, are criminal acts, and we're trying to make sure that we enhance the ability to collect that as much as possible. But what we are not going to collect under the amendment is speech. This underlying bill that I'm trying to fix is a very, very dangerous intrusion by the government out into the marketplace of ideas, surveilling people's speech, looking at ideas, political opinions that the government bureaucrats in this case don't agree with. Members, this is very important. Please vote yes, and Madam Speaker, I request a roll call.
Representative Niska requests a roll call. Seeing 15 hands, there will be a roll call. Representative Becker-Finn.
Thank you, Madam Speaker. This is a simple amendment. It's simply misguided. As I mentioned in my opening, this is a bill that combines the Judiciary Omnibus and the Public Safety Omnibus. What Representative Niska is speaking to would be in the criminal code. That's in the public safety side of the bill. The language that this amendment actually changes is in the judiciary portion of the bill under Chapter 363A, which is the human rights chapter. And I'm going to read what the actual language is in the bill. Give the Department of Human Rights, one of the things in the list of many things that the Department of Human Rights does, solicit, receive, and compile information from community organizations, school districts and charter schools, and individuals regarding incidents committed in whole or in substantial part because of the victims or others' actual or perceived protected class. And then the data would be compiled in the aggregate and the extent of the incidents with summary data. So there's no registry, there's no database. It's the compilation of data so we have a better idea of what is happening in our communities. Hopefully folks are aware, unfortunately, we've had a couple of fires that have been set to mosques in our state. And a story just came out, national NBC News, that the fear is very much there that that may have been motivated by hate. That the Muslim community is specifically being targeted, particularly at this time of year. And the idea is that if we have a better idea of what is happening in our communities, of the types of incidents that may not rise to a criminal level, beyond a reasonable doubt, probable cause, those are big deals. We are talking about getting a better handle of what kind of incidents are happening in our communities. If we, for instance, if we knew that there was a rash of swastikas being graffitied in a certain neighborhood, that might be a clue that we are on the path to something worse happening. It may give us information that will help us in making all of our communities safer. So that is what the bill does. And then also says that the commissioner shall provide information on the department's website about when and how a victim can report criminal conduct to a law enforcement agency. Department of Human Rights is not collecting data on crimes. It is on incidents of bias. It is a separate thing that we are doing here. This was led by community. They've been working on it for years. Jewish Community Action, CAL, many other organizations have come from us. The community has asked for this and asked for these community orgs to help be the hub so they can share what's happening in their communities. That is the language that's in the bill. It's good information. We already have a way to report crimes. This amendment is not needed. Thank you.
The member from Douglas, Representative Franson.
Thank you, Madam Speaker. Would Representative Vang yield to a question?
She will not. Representative Franson.
Would Representative Jamie Becker-Finn yield to a question?
She will. Representative Franson.
Thank you, Representative Jamie Becker-Finn. So speaking of the hate crimes, and there seems to be some perception around here, what is, what isn't. So if there is an individuals that per se believe in two genders, and that's male, female, and it is in their religious belief, because there's some court cases going on right now on pronouns. And so there was one just recently that was ruled on in the 6th District, Meriwether, let's see, what is it? Shawnee State University. In a federal lawsuit filed by the ADF in Ohio, the 6th U.S. Circuit Court of Appeals ruled last year that Shawnee State University violated the free speech rights of philosophy professor Nicholas Meriwether when they disciplined him for refusing to use a transgender student's pronouns. So if an individual, it is their belief not to use another individual's preferred pronouns, would that be considered a bias or a hate speech?
Representative Becker-Finn.
Thank you, Madam Speaker. That was a really long example from a different state. What this would do is that the Department of Human Rights cannot control what people would report to them. If the person reported it, then they would aggregate that data. But it would have to be an incident committed if the person believed that it was an incident committed in whole or in substantial part because of their actual or perceived race, any of the protected statuses, then sure, they could report that. But again, this is community driven. They're not like driving around looking for things to report. If people report it, then they'll compile that data.
Representative Franson.
Thank you, Madam Speaker. And if Representative Becker-Finn would yield to one more question.
She will yield. Representative Franson.
All right. So just to simplify then, could misgendering be considered hate speech?
Representative Becker-Finn.
Madam Speaker, yes, but not by the person who is being misgendered. If they believe that it is an incident of bias, they could report that. But somebody choosing to, I don't know why they would report themselves for imposing their hate on another person.
Representative Franson. Representative New Brindley.
Thank you, Madam Speaker. I got to say, what we are debating at this moment is crazy town. In fact, I had already written down 1984. As soon as we started discussing this amendment, I wrote down 1984, Orwellian. This is wild. I actually just reread 1984 over the summer, so it's fresh on my mind. And not only that, just a few weeks ago with my kids, a little lesser known, right? You don't talk about it as much. In fact, I'm mad that I didn't make my kids read the book first because it's so much better. But we just watched the movie The Giver, which has a very similar tone, right? There are these secrets of society that only the receiver and the giver are allowed to know. Society is not allowed to know about everything else. And then I started thinking, oh my goodness. So Representative Becker-Finn just said, we already have a way to report crimes. Correct, we do. And so all we're doing here with this underlying language is to create an entirely new category of crimes. There is no other reason to collect this data. And it's terrifying. I pulled it up. I went back, I couldn't remember all of the language, so I pulled it up, 1984, and it talks about a thought crime. And a thought crime describes a person's politically unorthodox thoughts, beliefs, and doubts that contradict the dominant ideology of Oceania. If you're going to contradict those things in your thoughts, that's a thought crime. And then it goes to crime think. Crime think describes the intellectual actions of a person who entertains and holds politically unacceptable thoughts. That's crime think. Honestly, you cannot look at this underlying language and come to any other conclusion but that is what we are doing here. We are creating a database of thoughts and speech. This is absolutely Orwellian. And the next step, folks, is Minority Report. The next step is we're going to start arresting people before they commit the crime because we've got the thought database now. We know what the crime thoughts are. This is nuts. So thank you, Representative Niska, for at least ensuring that this database is based on actual crimes and not thoughts, not words. My goodness, folks, the thought, we are literally, I cannot even wrap my head around what is happening in this chamber right now. I cannot wrap my head around this. We're literally saying that if somebody doesn't like, if somebody feels bad by what somebody else says, if they feel bad, they're going to report that. And that is now going to be in a database. What? For what? It doesn't say actually what we're going to do with it. It doesn't actually say what we're going to do with this thought crime database. We should have that data. We're just going to start collecting it now. This is freaky stuff. I cannot, folks, honestly, Certainly in my time in the legislature, I'm pretty confident in the history of the legislature, we have never seen anything like this. Because as it turns out, to this point, we have understood that it is not the job of government to control people's thoughts. It's not the job of government to control people's words. It is the job of government to hold people accountable for criminal action, for criminally hurting other people. But this feeling stuff, this interpretation stuff, this is not the role of government. And where this leads is terrifying.
The member from Wright, Representative Hudson.
Thank you, Madam Speaker. Members, I just want to try to recenter the discussion, piece together different bits that have been dropped along the way by different representatives. First of all, Representative New Brindley is 100% correct, and that's confirmed by the author from the presentation of the bill in committee. This is about how the person reporting it feels, 100%. And we just heard it affirmed yet again tonight, where Representative Vang said that in answer to an inquiry from Representative Niska about whether or not a particular situation would qualify, instead of directly answering that question, pivoted in exactly the same way that she pivoted in committee, which was to say, listen, you wouldn't understand. You don't have this experience of being oppressed. And when Representative Niska rightly stood up and raised a point of order, stating that that was invoking personalities, we saw this strange thing happen, and it happened collectively on the majority side, where you all kind of gasped, and you're like, what are you talking about? I heard that said in the chamber. What, personalities? No, we're not saying that. Now, since there hasn't been an explicit explanation offered as to what was going on there, I'm left only to infer, but the logical conclusion would be that what was being said was that because Representative Harry Niska is white.
Point of order, Madam Speaker.
Representative Long.
Mason's 101 debate must be confined to the question before the body, and Mason's 124, we need to avoid personalities.
Yeah, just couple of things. Members, there are folks in the chamber who are letting me know they can't hear. This room is designed to have excellent acoustics. So when you're in different parts, there are other parts where your voice can be heard, which you may not realize other people can hear you. And so if you could please take any conversations that are not in the debate into your microphone off of the House floor, that would be helpful. I think we are all at our best in the debate when we explain our point of view without referring to what we think other people think or what we think other people are motivated by. And that way we can steer clear of intent and motive. And so I would just not rule on the point of order, but just advise everybody, I know it's 9 o'clock at night, this is a very intense bill, but if we can just speak from our own point of view and not surmise what others may be thinking or meaning, that will help us. Representative Hudson.
Thank you, Madam Speaker, and let me just say, I wouldn't have to surmise if clear answers were given and clear language was used, and you actually said what you meant. Now, maybe I'll forego asking Representative Vang to yield to a question to clarify what your intention was, what you meant. But suffice it to say, logically, if it didn't count as evoking Representative Niska's personality when you said that he's somehow incapable of understanding what we're talking about, if that wasn't evoking his personality, what was it evoking? Will Representative Vang yield to a question?
She will not. Representative Hudson.
I don't blame you. I don't blame you. Because you know I'm right. And you know I'm right. Minnesota knows you're right. This is disgusting. There's been a long list of disgusting things that have happened in this chamber over the course of this session, but this ranks right up there. Examples have been offered in committee. One of the examples that was offered by the Commissioner of Human Rights as a potential incident that would be included in this aggregate data, to yield to Representative Becker-Finn's categorization of what it is that we're talking about here. I guess the difference between database and aggregate data is somehow meaningful. Either way, it's the government collecting information about non-criminal speech. Not quite sure the particular details of how we describe it is relevant. It's government collecting data about speech that is not criminal and therefore has no compelling state interest in being collected. And then what do they do with the data? Good question. Not addressed. Not addressed in the bill, but it was addressed in committee, wasn't it? It was said, we're going to use this data to identify hot spots of bias, to label communities as problematic, based upon subjective, unverified, unobjective, vague, arbitrary claims of bias. So vague, so arbitrary, so beyond the grasp of being able to quantify and identify objectively, that every single time, either in committee or here tonight on the House floor, when Representative Vang has been asked whether or not she could categorize whether or not a particular hypothetical situation would fit into the mold, she either refused to yield to a question, which has happened twice now tonight, or said that she couldn't offer the answer. If this was objective, if this was dealing in something that's real, that's tangible, that we can examine, that we can judge, then you'd be able to say so. You'd be able to give a clear yes or no as to whether or not the examples that Representative Niska provided would qualify as something that can be reported under this provision. And the fact of the matter is, again, as has been described tonight by Representative Vang and in committee, literally anything that happens to you that you feel is based upon your actual or perceived racial identity qualifies as something that can be recorded. And on that basis, we're going to aggregate the data in order to determine the problematic communities. I'm sure there's nothing that could possibly go wrong with that. The looks of perplexity and confusion just astound me. I'll tell you, if this bill were the law of the land in Minnesota today, I would encourage Harry Niska to file a report, because he was the target of bias in this chamber tonight. And through extension, many other members in this chamber on both sides of the aisle. This is a dark moment. We're going to explicitly target non-criminal speech for scrutiny by the government for undisclosed purposes. If that's not reason enough to vote green on Harry Niska's amendment, then I don't know what is. Thank you, members.
The member from Hennepin, Representative Hassan.
Thank you, Madam Speaker and members. I want to give you a background on why the bill that Rep. Vang has been carrying, the reason why we're carrying this bill and the reason why we need this bill. 2 mosques have been burned in the last 48 hours in Minnesota. 2 mosques. And they are the target of hate and bigotry. And we're sitting here pretending that there is no problem, that we don't need bills like the hate bill to protect people. Thank you, Rep. Vang, for carrying this bill. Thank you, Chair Hounstein, for carrying this bill years before. And thank you, anyone who has supported this bill, because for some of us, hate is a real thing. Bigotry is a real thing. For some of us, we're targeted because of our religion, because of our skin color, because of our ethnicity, because of where we came from. That is the reality, folks. And we're sitting here pretending that that is not a thing, and we are controlling speech. This bill does not control speech. This bill, what it does is it protects people. There is a whole community tonight that is worried about going to their faith space, the most sacred space that they can be in, because somebody decided to write cartoon on Star Tribune, and then somebody decided to act on that and go and burn a holy place. That is the reality of Muslims in this state. That's the reality of Jewish community in this state. That's the reality of the Asian community when COVID was happening. That's the reality of people who are not mainstream. And that's not what we're talking about tonight. We're talking about we're disgusted, we're disappointed that this is crazy. What is crazy for me and people who look like me is the fact that we're not talking about mosques being burned down, synagogues being burned down, people being targeted because they're from Asia or because they look like that they're from Asia. That's the reality that we live in. And today, what we choose to talk about, we choose to talk about, oh, this censors speech. I am disappointed.
The member from Anoka, Representative Engen.
Thank you, Madam Speaker. Will Representative Becker-Finn yield for a question?
She will yield. Representative Engen.
Representative Becker-Finn, the term implicit bias is stated in Minnesota statute many times, such as section 144.146. It's defined as a form of bias that occurs automatically and unintentionally that nevertheless affects judgments, decisions, and behaviors. Do you believe that implicit bias exists?
Representative Becker-Finn. Members, I just want to caution you that we're going down a path that doesn't relate to the language in the bill or the language in the amendment. Representative Becker-Finn.
Thank you, Madam Speaker. Yes, implicit bias does exist. However, I will also remind you that you can't just pull a definition from some other chapter of statute and apply it to every other chapter of statute. That's just not how statutes are interpreted by judges. That just is not how statutes work. I do want to point out, though, one thing that has really, I think, we've gone off the rails a bit, and I want to get back to what is actually in the language. First, I think it is kind of ironic that we got some quotes from a book that's being banned in some other states. But the thing that I think is really important is if someone believes that they have experienced an incident of bias, they should report it. And what this bill actually gets to, again, it's in the human rights statute. What this really gets to is the perspective of the person who has experienced the incident of bias. It isn't about keeping a list about the actor of the incident. It's about keeping track of what is happening to our communities. That is the point of this. That's why it is not in the criminal statutes. It is in the human rights statute. There is no mold. If you report it, it will be taken in with all the other data. It is up to Minnesotans to report it if they believe that they have experienced an incident of bias. So there's no mold. There's no list of bad guys. It's keeping track of what people are experiencing in all of our communities.
Representative Engen.
Thank you, Madam Speaker. And Representative Becker-Finn, if that's the case, then why are we tracking it in the first place? We're not doing anything with it. You said implicit bias exists. If it does, then aren't all perceived incidents, no matter what interaction we have with somebody in the public, couldn't that potentially be perceived as exactly the type of bias-related incident that we're looking to track? If we all have implicit bias, then what we're looking for is everything. It makes zero sense. What are we doing here, guys? This is thought speech. This is looking for issues where they don't even exist at times. Implicit bias can't exist while simultaneously we're looking for specific incidents where bias exists. We all have them. I suggest we take a look at that before we go ahead with this provision. Thank you.
The member from Wright, Representative O'Neill.
Thank you, Madam Speaker and members. Madam Speaker, will Representative Vang yield for a question?
She will not. Representative O'Neill.
Thank you, Madam Speaker. I thought I'd give her a chance since it's her bill. Madam Speaker, will Representative Becker-Finn yield for a question?
She will. Representative O'Neill.
Thank you, Madam Speaker. So, Representative Becker-Finn, yesterday, I believe it feels like it's been a long week. You were in front of Ways and Means, I believe. And if it wasn't yesterday, I apologize. It's been a really long couple weeks. So We had quite a conversation back and forth about this particular provision. And, as I was listening to the debate, it raised a lot of questions. And you know me, I ask a lot of questions in committee. I don't typically ask a lot of questions on the floor. But this is one of those times. So my question is, if someone reported on me to the Department of Human Rights, made a report, would I know? Would I be informed that somebody reported about me?
Representative Becker-Finn.
Thank you, Madam Speaker. That is not outlined in the language, but there would be no consequence to you. Again, the point is to get the point of view of what people are experiencing in our communities. It's not about going after anybody. It's not about reporting crimes. It's about getting a handle of what people are experiencing in our communities. So, and I will point to the data collected and maintained under this clause are private data on individuals, so that is outlined in the language.
Representative O'Neill.
Thank you, Madam Speaker. Thank you, Representative Becker-Finn. Yes, I see that it's private data, but the person that's being reported on, that should be available to them, wouldn't you think? But here's my reason for saying that, Representative Becker-Finn. So if somebody reports on me to the Department of Human Rights, and it goes into this database, and I don't know if it's filtered out or not filtered out by the Department of Human Rights, if it's substantiated or not substantiated, if it's just raw data coming in, and any report coming in is just put into this database. There are always two sides to everything, right, members? So if someone reports on me and I don't know, I have no ability to explain the situation, to maybe it wasn't even me, maybe it was someone else, I don't know, and maybe that's not important for the data. But I would think that if we're going to be collecting data and surveilling our population, which is what I said in committee, that this is government surveillance. And the reason I say government surveillance is because it has a very specific word in the language, which is solicit. If you've got your bill out, take a look. And if you look at the amendment, the NISCA amendment, it deletes the word solicit. The word solicit means those two employees from the Department of Human Rights will actively look for information. They're not sitting there passively receiving it. They are soliciting it. They are soliciting it. They are going out and looking for it. They're going out into community and looking for these things. That's what solicit means. That is why in the NISCA amendment, it deletes the word solicit. That is the government surveillance part of this bill. And interestingly enough, Representative Becker-Finn, when we were talking about this in Committee on Ways and Means, and I asked about that, and I realized that it's Representative Vang's bill, but she wasn't in Ways and Means because it was rolled into your bill, and she won't yield to a question here, and that's fine. But that makes a big difference. And in fact, when we were discussing it in Ways and Means, it was characterized very differently than that. In fact, I recall you refuting that it was government surveillance. But when you use the word solicit, that is exactly what it is. And whoever is being reported on won't know that they're being reported on. They have no way of refuting what was reported. And I have one more question, Madam Speaker, if Representative Becker-Finn would yield.
She will yield. Representative O'Neill.
Thank you, Madam Speaker. So, Representative Becker-Finn, does the Department of Human Rights, in the language, do they have the authority and ability to filter out reports, or will they just take every report that comes in and put it into the database?
Representative Becker-Finn.
Thank you, Madam Speaker, and thank you for the question. Whatever data comes in is the data that will be collected. I think it's really important solicit does not equal surveillance. Solicit could be putting on the Minnesota Department of Human Rights website, this is how you make a reporting of a bias incident. It could be holding a community meeting in one of our impacted communities so people could talk about it in that kind of meeting. It could be meeting with Jewish Community Action and getting reports from them of things that have happened. Solicit doesn't necessarily mean surveil. I also wanted to make sure that it was clear that if you are the subject of a data, you could make a data request if you were aware that somebody had reported you. But again, they are reporting the incident and what they experienced. They are not reporting you. It is not a list of actors of incidents of bias. It is meant to incorporate what people are experiencing in the community, the person who is having it done to them, not the person doing the action. We want to know what's happening, the incidents. So again, they're reporting the incident, they're not reporting a person.
Representative O'Neill.
Thank you, Madam Speaker. Thank you, Representative Becker-Finn. But they could. They certainly could include anything because it's not being filtered out. It's just receiving, the Department of Human Rights will just receive every single report that comes in with no merit, no measure, no filtering, whatever comes in, and reporting it as acts of bias. The person being reported on won't know. It's going to be collected, rolled up together. So, Madam Speaker and Representative Becker-Finn, thank you for those questions, or thank you for answering those questions. I appreciate that. Just like I said in committee, I'm going to say it again here. If it's an act that is criminal, it should go to law enforcement. If it is something that has violated the Human Rights Act and those statutes, it should go to their very large department that can investigate that. And you're adding 16 investigators in this bill. There are 2 investigators that are solely for this purpose, and I'm going to continue to call it government surveillance because that is exactly what it is. And if you don't want it to be government surveillance, then take this amendment. Thank you, Madam Speaker and members.
The member from Carver, Representative Nash.
Thanks, Madam Speaker. Members, I want to convey something to you. Representative Vang, Representative Hassan, anyone who talks about some of these hate crimes, I'm with you. These are absolutely abhorrent behaviors. I think it's the absolute worst that a person can be to do that. And I'm just going to put it out there. I would love to see the people who do those things, who burn and blow up mosques or who spray swastikas on buildings, they should go to jail for forever. That's the Jim Nash thought. Just put them away. That's for me. That's where I am. And I have a couple of friends in your end of the political spectrum who I am in lockstep with. That I told one of them when they had a swastika painted on their home, I said, if you would like me to come down and help scrub that off, I'll be there. That's absolute garbage, and those people should be prosecuted to the full extent of the law. But that's because they've committed a crime. They have done something that is so outrageous from my perspective that, yeah, let's just put them on the fast track, put them straight in jail. I have no problems with that because that is absolutely disgusting behavior. But what we see here is, and it's line 50.26 on page 50 of the bill, it says solicit, receive, and compile information. My fear is this, and I've shared this story before. We had a neighbor many years ago in Waconia that, I don't know what happened. They didn't like my wife, and if you know me, you'll know that I'm nice because my wife is nicer and she makes me, yeah, thank you. They've met my wife. They're like, oh, wow, she's a saint. But so one of our neighbors didn't like our kids playing in the yard loudly, and they filed a complaint with Child Protective Services. And it was completely capricious. And the deputies came and they said, this is an assault on your family, or at the time, Mayor Nash. My fear is that this kind of behavior can be used to weaponize against someone that you don't like. And I am very troubled by the words on that line, on line 50.26, that we're going to solicit. Solicit means that you're going to cast a net out there. You're going to ask for input from somebody who may say, you know what, I don't like that, insert name here. I'm going to say that they said something, and then we go down that road. And as you collect that data, I have a question, and if Representative Becker-Finn would yield to a question.
She will. Representative Nash.
Thank you, Madam Speaker. Representative Becker-Finn, there's in the provision that's in there, there's no conversation or language about the retention time frame of those records. Would you tell us how long that data that is compiled and solicited and received, how long would that be stored for?
Representative Becker-Finn.
Thank you, Madam Speaker. Was not anticipating that question to be whatever the typical standard is for how they keep track of data.
Representative Nash.
Okay, so sometimes data is held for a period of years. Here's my fear on this. So let's use the scenario that I just used, that because it happens. Someone is doing something to somebody capriciously. It's now stored in a database for a long period of time. In the IT caucus that we have here, we can tell you that it's not hard to compromise a database, and that data can get out there and it can be used to further weaponize somebody's reputation. And I share my colleagues' fears that as we are now soliciting potential problems with someone's thoughts or words that they've expressed, and I think that we should be very careful with our words, but we should also make sure that we're not going too far and doing something. And I will tell you, Representative Vang, I don't know if you were here for what I said. I think you may have been off the floor. I volunteered to be on the API community board for one of these very reasons, because hate against a group of people is absolute BS. I think I can get away with that because she's not looking. That's BS. And we should all agree that that's the worst behavior that we could possibly do. But this goes a little bit further, and that little bit further puts it in the category of way, way too far. So Representative Hudson's right, Representative Brindley's right, Representative Niska's right, Representative O'Neill is right. I'm with you. And you know what? If something happens, I will give you my phone number. If someone does something that is hateful for your community, like I had with my Jewish friend, I will come down. I will help you remove all that crap off of your home. I will stand side by side with you, and I will say that that is absolutely BS. But I would hope that you would stand with us to say that this is too far. This goes too far. Thank you.
The member from Wright, Representative Hudson.
Thank you, Madam Speaker. I'll keep it brief. I just want to try to put a bow on it, so to speak. The idea that we just want to know what's going on, that's been said here tonight by Representative Becker-Finn. It was said by Representative Vang in committee. It was said by the Commissioner of Human Rights in committee. We just want to know what's going on. Well, so does any security camera, right? I mean, that's literally the definition of surveillance. You just want to know what's going on. The question is, do you have a right to know what's going on? As government, do you have a compelling state interest in observing and documenting and storing information about what is going on? And the examples that have been provided here tonight of the motivations, not my guessing what the motives are, but stated in very clear terms by Representative Hassan, what's motivating this is crimes are happening. Crimes that are atrocious and motivated by hatred and bigotry. Well, that's not germane, because this provision doesn't have anything to do with crime. This provision, and this was an author's amendment by Representative Vang in committee, she explicitly replaced the word crime with incident. So she took the time to ensure that this provision has nothing to do with crime, nothing at all, and very intentionally replaced it with the word incident. Why? Because you guys want to know what's going on with non-criminal incidents. And that's a problem. It's a problem that you recognize in other exercises, other provisions that you've brought to committee and brought to the floor. and that you ought to broadly recognize as anybody who's passed even basic constitutional law or civics. The state doesn't get to just decide that it wants to know things. That's why we have things called warrants. We've talked a lot about those tonight, right? The idea that you can't just come to a judge and say, hey, I want a warrant to know something about this guy over here. And then when the judge asks you why, you just say, well, I just want to know what's going on. I would hope that any judge worth their salt would immediately shut that down. I think it's fair to say any judge in Minnesota would. So this idea that you just want to know what's going on, I'm sorry, it's not good enough. You need to disclose why, on what basis, how it's constitutional, how you are not, you have to affirmatively demonstrate that you are not violating the rights of the residents of Minnesota before you do this. To just blanketly start collecting data about speech for undisclosed purposes, not only can you not tell me why you need it, you can't tell me what you're going to do with it. That is a lousy warrant. That is the most sloppily written warrant I have ever heard. But that's what you've offered here tonight. That's what's been offered all through the process as this provision has made its way through committee and now made its way here to the House floor. This is embarrassing. Vote green.
The member from Ramsey, Representative Herr.
Thank you, Madam Speaker. And I really appreciate the conversation tonight. And I'd like to shift us maybe a little bit away from where this direction has gone. So I heard the question of why, that you haven't heard the why we're doing this. So I'll share a little bit about, I didn't work on this bill, but I want to thank Representative Vang for bringing it forward and Representative Hornstein, because when all of the anti-Asian hate was happening during COVID, I was really, truly afraid, and afraid for me and my children. But nobody committed a criminal act against me. Nobody committed a violation of human rights against me. But what people did do is, when I'm walking in my neighborhood, somebody did call me a gook and threw garbage at me. What is the cost of collecting that data? When my children are waiting at the bus stop because they don't drive, and so they're waiting at the bus stop, and I hear people saying to them, comments about how they brought the coronavirus here and we're not even Chinese, never been to China. What is the cost to collect that data? And so when I wanted to ask for funding for the state to say, how can we address the hate that is happening, because people are truly fearful for their lives? And the state said to me, and people said to me, you can't, because we don't have the data. And so I called California, and I said, California, what are you doing? Because we're seeing increased incidents of hate. And California said, we don't have the data either. And what we did was, as a network of Asian Americans across the country, we all said, what do we need to do to collect data so that we can address a situation that no one believes us is happening? And so the only way we can do this is to say, we need to collect data that is not criminal. We need to collect data that is not a violation of human rights. And you may feel okay leaving your house during the day, but I have a 19-year-old daughter and a 23-year-old daughter, and I, for the first time, understood what it meant to be afraid that my children would not come home because somebody decided that they were somehow responsible for the coronavirus. And emotions were high during that time. I was afraid for my children. And so what is the cost of collecting data so that we understand the extent of a problem? If you want me to wait until it is criminal, I do not want to wait until my child is hurt. I do not want to wait until somebody burns my house down. I do not want to wait, because if I can see that tensions have been rising because the data shows me that the data is saying certain groups are experiencing heightened hate towards them, that signals us to say, let's do something different. And the truth is you're right, we all have implicit bias. I do too. I was socialized as a woman of color in the same institutions that socialize white people. And so yes, I am going to have things that I do that could hurt other people. And I would hope that if I did that and it did hurt someone, someone would report me. I would hope that. And to be honest, I think I might be the only person in here who was actually a human rights commissioner. I was a human rights commissioner in the city of St. Paul. And all the things that you are talking about, I'm so disappointed in, because the truth is that when people were coming to me with issues that were not criminal and were not a violation of their human rights, I couldn't do anything about it. I couldn't even put that information somewhere so that I could see who was disproportionately being impacted. And it will come around. If it's not our Muslim brothers and sisters, it's our LGBTQ community. I have received tens of thousands of hate telling me I should kill myself, telling me that my children and I do not deserve to be alive because I defended trans girls in sports. Those are incidents of implicit bias and hate that we should be tracking. And I don't know why it hurts us to do that if we can prevent a trend of something from happening. So if you want to know why, that is why. This has nothing to do with individual attack on people or their character or if they're doing wrong things. This has to do with us trying to do the right thing for people. And so I'm sorry that there are people who feel like this doesn't impact them and we're doing this frivolously. But those of us who have to live with this is what we experience. And so I ask that for us to remember that this has nothing to do with attacking anyone's character, but saying there are times in which certain communities experience increased hate. That is not criminal, that is not a violation of their human rights, but equally impacts them in their ability to live their life. I'd ask for you to support this because it is common sense for us to do this work. So thank you so much, Madam Speaker, for giving me the opportunity to speak on this.
The member from Hennepin, Representative Hornstein.
Thank you, Madam Speaker and members, and again, appreciate the discussion. Representative Nash, thank you for your comments, your empathy, your understanding about what people go through who are victims of hate crimes. Some of you on the Education Committee know I shared my parents' story of Holocaust survival in a hearing that related to Holocaust and genocide studies. And as both Representative Hassan and Representative Herr mentioned, we started this work right after Charlottesville. And a group of people got together from communities that have experienced historic hate crimes. And the issue that surfaced at those meetings was we feel that hate crimes are underreported and that the community should have a mechanism for reporting. The FBI has identified this as a very, very serious issue. Less than 1/3 of hate crimes and hate incidents are actually reported. So the origins of this came at that meeting right after Charlottesville, and we've been working on this for a number of years. Now, I'm not necessarily advocating we do here what they do in Germany. But something that I think has been very powerful for me is the fact that the Germans in many ways have really tried to address this history and work hard at reconciliation. You know, they killed 6 million of my people. It's really hugely, hugely significant. And so I'm going to quote from you from a frontline story that PBS did just last year, the year before, about how the Germans deal with this issue. The German Penal Code prohibits publicly denying the Holocaust and disseminating Nazi propaganda both off and online, including sharing images such as swastikas, wearing SS uniforms, and making statements in support of Hitler. It places strong rules on how social media companies must moderate and report hate speech and threats. And then I'll just conclude, there's a lot of good information. I'll send this around to the body since we've had a very good discussion tonight about this issue. But Christine Lambrecht, the Minister of Justice in April 2021, made a statement that's saying, this is a serious threat to our democratic society when people are attacked because of their name or their appearance, or are silenced because they express themselves politically, scientifically, and socially. That's what we're trying to get at. I think we can learn a little something from the Germans. And I just want to conclude by encouraging the body to look at the exhibit that is just across from our caucus rooms on the first floor. It's up until the end of April, because April is considered Genocide Awareness Month. And so you'll see a lot of exhibits about the Holocaust, the Armenian genocide, the genocide of indigenous peoples, or Rwanda. You know, just yesterday there was an acknowledgement of the Armenian genocide. So much has happened in April. We had Holocaust memorial evening last week in the Jewish community called Yom HaShoah. That's the ultimate hate crime. That is what we are worried about. And so speech can lead to violence, which can lead to really bad things. That's where I was That's how I was raised. We knew all along that this could happen and it could happen again. And so what we're doing here, whether it's a fire in a mosque or the 339% increase in AAPI hate crimes, the significant increase in violence against transgender people, particularly transgender women of color. We have had record numbers of incidents against the Jewish community over the last couple of years. This is the issue that we're responding to. And yes, it is criminal, but there are also examples of violence that are speech that leads to violence. And yes, there's a fine line on the First Amendment. I get that. And I'm not necessarily advocating for the German model. But I think we can also learn from the German model as well. So that is really the origins of this bill. And I appreciate the conversation tonight, and I hope we'll vote for the bill. And I would say recommend a no vote on the amendment.
The member from Washington, Representative Anderson.
Thank you. I'll be brief. I try to stay in my lane on my issues, but I just have to speak on this. You asked what's the cost of collecting this data? The cost of collecting this data is the cost of liberty. It's the cost of freedom. It is a line, it is an absolute road to oppression. And that's what we have seen throughout history. The other representative talked about the First Amendment and about people being able to express themselves politically and socially. I'm a little older, and I never thought in my lifetime that we would be trying to stop each other's speech, trying to say what people can say and what people can't say. That we would ever try to do this, and that is what we're doing. And this bill is creating a government entity that's going to try to tell us what we can say so that all of us would fear this entity. This is a road to oppression. This is so against the American, this country. It's incredible. It's wrong. It's a violation. I hope we all vote no. Thanks.
Representative Niska, closing argument.
Thank you, Madam Speaker and members, and thank you for the discussion. And I really do appreciate some of the folks who across the aisle who have shared their personal experiences. And I know those stories are not easy to share, and I hear them, but I strongly disagree with the idea that we should trust the government to always be on the side of the side that you think is good, and that we should reach out and have government surveillance to try to catch crime before it happens. That's Minority Report. That's 1984, where we're having the government reach out and decide not things that are criminal, but looking at thoughts and ideas and surveilling them, deciding what to do about them. But I think it's very important as we close here that we look at what is the language of the underlying bill and what is the language of the amendment and how do they differ, because I think that a lot of the points that were made are reasons why we should support the amendment. Mosque burnings, genocide, those are horrific, horrific things. I think if we had a vote in here about a pretty significant punishment for whatever, I won't use the word, whatever guy they catch who burned that mosque down, I think we'd have a pretty strong vote. But that's why it's important that when we look at these things that we tie it to criminal action, that we tie it to things that it's legitimate for the government to regulate and not to regulate. And the amendment simply adds into the direction to the Department of Human Rights, between the words regarding an incident, criminal incidents. Now, Representative Becker-Finn, I appreciate the point that it's hard to prove a crime. We're not telling the Minnesota Department of Human Rights that they have to try and convict somebody before they put it in there. We're giving them direction about the types of incidents that we are wanting them to receive and compile information about. We're telling them that they shouldn't go out and solicit. They shouldn't have a government surveillance database in the amendment. And we're also then taking out a speech surveillance database that's the underlying bill puts in the Department of Human Rights. The underlying bill says that they will compile data in the aggregate on the nature and extent of the incidents and include summary data. And Representative Becker-Finn kind of elided those two and made it sound like all they were going to do is collect a summary. No, they are going to collect the data in the aggregate. What does in the aggregate mean? It means a whole bunch of things together in a whole. They're going to have a database that then we don't even really know. Representative Nash says maybe it's 6 years. The Department of Human Rights gets to decide what their data retention policy is. We don't set that in statute. Who knows how long they're going to hold this bias, this speech registry. It's a snitch line. Folks, we've asked about examples of this. I had asked Representative Vang in Judiciary Committee. She said the Judiciary, that the Department of Human Rights has discretion. Representative Becker-Finn says they don't have discretion, that it all goes into the database. I don't know which is the case from the underlying bill, but what I do know is that every single one of us in here has done something that under this bill we could get reported to the Minnesota Department of Human Rights and put into their database. If somebody decides to snitch on us, the government, for something we said, whether it's having an opinion that somebody doesn't like about where COVID-19 came from, whether it's having an opinion about whether white kids should feel guilty about American history, whether it's having an opinion about whether certain Christian colleges should participate in the PSEO program. All of us have done something and said something on this floor or had a vote on this floor that somebody could report to the Minnesota Department of Human Rights and put into their database. So members, I want you to think seriously about this question before you vote on this amendment or vote for the underlying bill. How confident are you that the Minnesota Department of Human Rights, that the people at the Minnesota Department of Human Rights keeping this database are always going to be on your side? How confident are you that the speech they choose to compile or not to compile and what they do with it fits your views, or whether they decide to target your views? And members, we saw not too long ago, relating to this body, an incident that should give us all pause. And I'm not going to go into the details. We all know what I'm talking about. But if a member of the Capitol Press Corps can feel threatened, can feel silenced because someone labels something as harassment, think about what the Minnesota Department of Human Rights might do to ordinary people, people who don't have the power of being a member of the Capitol Press Corps. And think about the times in our American history when this kind of power has been wielded for bad. Think about, I'm staunchly opposed to communism, but I think the McCarthy era was bad. I don't think the government should be surveilling people's views, should be thinking about, are you now or have you ever committed a crime of bias? Are you now or have you ever thought bad thoughts or said bad things that somebody might perceive to be a statement of bias, an incident of bias? Members, this is the bedrock principle of our First Amendment. This is not the government's role. The government doesn't get to be the one that goes out into the marketplace of ideas and looks at who is saying bad things, who's thinking bad thoughts. That's what this bill does. My amendment tries to get it back to what Representative Hassan was talking about, a bill that protects people, that says we're going to go after people who bomb mosques. We are going to go after people who bomb synagogues. We are going to track them, and if people don't have a hard time reporting those to the BCA or to law enforcement, that's what my amendment is doing. It's saying that the Department of Human Rights can be a conduit, that community groups can be a conduit through the Department of Human Rights, but we're looking at things that are criminal, not speech. It's real simple, folks. This is about, are we for government enforcing the law and looking at what crimes are happening, or are we about having government create a speech surveillance database? Members, please vote yes.
Seeing no further discussion, the clerk will take the roll on the amendment. The clerk will close the roll. There being 61 ayes and 70 nays, the motion does not prevail. The amendment is not adopted. There is an amendment at the desk. The clerk will report the amendment.
Myers moves to amend Senate File Number 2909, the unofficial engrossment as amended. The amendment is coded A12.
The member from Hennepin, Representative Myers.
Madam Speaker, I am moving the A12 amendment, which is something that we're trying to get law-abiding gun owners to do, and that is to ensure that we get sales of those guns into people that should have those guns. So what the amendment does is it provides immunity to a person from prosecution for a firearms transfer if the person produces a copy of the permit to carry or a permit to purchase that was used for the transfer. This amendment is going to incentivize gun owners to request the documentation that they need so that we can ensure that law-abiding gun owners, get the guns that they're looking to get. So I would ask everybody to support this amendment.
There is an amendment to the amendment. The clerk will report the amendment.
Pinto moves to amend the Myers amendment to Senate File Number 2909, the unofficial engrossment as amended. The amendment to the amendment is coded A38.
The member from Ramsey, Representative Pinto.
Thank you, Madam Speaker. And Representative Myers and members, I appreciate some of the thought of in the A12, the underlying amendment. If a seller, in fact, is able to see a permit to carry or permit to purchase under the provision, the criminal background check provision that is in the underlying bill, we certainly would not want them to be held liable if, in fact, the person, the buyer, were to use the weapon later on with no fault of the seller. So that general concept makes some sense, but there does need to be some improvement to it, and that's what's offered in the A38. We've changed immunity to an affirmative defense, which is a little more proper under the language legally. And then one really critical point, Representative Myers, is that your underlying amendment, the A12, would take away liability if it's reasonably foreseeable that the buyer was going to use the gun in furtherance of a crime of violence. So if the seller knows the gun's going to be used that way, that's not something we want to make an exception to, right? You wouldn't want to have it be that the buyer says, hey, I just want to let you know I'm about to use the gun to go commit a crime, to go shoot up someplace. We wouldn't want that to be the case. And so the A38 narrows the A12 to make this make a little more sense. And if we can make that modification, I think it's a good improvement to the bill. So I'd ask members to support the A38. Thank you, Madam Speaker.
Representative Myers.
Thank you, Madam Speaker. I'll request a roll call on this one.
Representative Myers requests a roll call. Seeing 15 hands, there will be a roll call. Representative Myers.
So, Chair Pinto, my intent here was to incentivize lawful gun owners to do everything that we want them to do and not trip them up. I think incentivizing them helps ensure that, firearms stay out of the hands of prohibited people. Chair Pinto's amendment kind of is a step back from what I was trying to accomplish, and it tells gun owners that even though, they do everything we want them to do, we're still going to charge them with a crime. We're still going to ask them to defend themselves in court. I do appreciate at least the affirmative defense, but I think we should be, treating our law-abiding gun owners better and not charging them with a crime So now they have to present evidence, even though they follow the law. So I would ask everybody to, the members here to vote your conscience on this amendment to the amendment.
Representative Pinto.
Thank you, Madam Speaker. I'm really glad that a roll call was requested because I want to direct members' attention again in the A12, lines 1.12 to 1.13. If you vote against this amendment, you are saying that if it's reasonably foreseeable to the seller that the buyer is going to use the gun to further a crime, to use a crime of violence, use that gun in a crime of violence, you're saying that all that the seller needs to do is just have the buyer show a permit. Buyer can say, yep, here's my permit to carry, permit to purchase. I want to let you know I'm about to use the gun to go fire some shots someplace to commit the crime of violence. I don't think that that's what you want to do, members. I don't think that that would be an appropriate thing. If it's foreseeable to the seller the gun's going to be used in that way, my goodness gracious, we would want to make sure that we hold that seller accountable no matter what kind of paperwork is shown. So that is not something we want to do. I would urge members to vote in favor of the A38. Thank you.
The clerk will take the roll on the amendment to the amendment. The clerk will close the roll. There being 68 ayes and 61 nays, the motion prevails. The amendment to the amendment is adopted. We are on the Myers underlying amendment as amended. Representative Myers.
Thank you, Madam Speaker. And as to the amendment as amended, I would, ask the chamber to support it. Thank you.
Representative Pinto.
I thank Madam Speaker, and I agree. Thank you.
All those in favor of the Myers amendment as amended, please say aye. Aye. Those opposed, please say no. The motion prevails. The amendment is adopted. There's an amendment at the desk. The clerk will report the amendment.
Doubt moves to amend Senate File Number 2909, the unofficial engrossment as amended. The amendment is coded A15.
Representative Doubt.
Thank you, Madam Speaker and members. This was a bill that I carried back during COVID that would have just been kind of an update to our statute. So on the portion of our statute for application of permits to carry a firearm, those must be submitted in person. Currently, my amendment would make that so that they could be submitted electronically by facsimile, certified mail, or certified delivery. And in a effort of really good, the way that this place should work, I've been working with the author of the amendment to my amendment, and I think we've come to an agreement on how we want this to go into conference committee. So I'm going to stop talking, and I'm going to let her offer her amendment to the amendment, and then we'll kind of talk to you about what we think and what our agreement is.
There's an amendment to the amendment. The clerk will report the amendment.
Becker-Finn moves to amend the Dowd Amendment to Senate File 2909, the unofficial engrossment as amended. The amendment is coded A45.
Representative Becker-Finn.
Thank you, Madam Speaker. Yes, the A45 is my amendment. Obviously, the underlying amendment refers to facsimile, so this language needs some updating. We've got an agreement to move forward with the first part of my amendment to the amendment, and then work together along with the Sheriff's Association to get this language right. Again, working in good faith across the aisle on a gun issue right here live on the House floor.
What do you know? We can talk to each other outside of the microphones. Representative Dowd.
Thank you, Madam Speaker, and I very sincerely appreciate the chair's efforts to help work with me. This really for me was updating, and they did mock me a little bit about the language to submit something by fax, which nobody does anymore. So what we want to do here, and we've agreed to kind of do this via voice vote if the chamber would play along, and we're going to send this into conference. I think we both understand that this needs a little more work in conference committee, and we don't want to put anything on the sheriffs that's going to cause them more work or trouble. So we're going to send a little bit of language into conference committee, and I've committed to continue to work with them to fix that. So I'm going to move to divide the amendment between lines 1.5 and 1.6, and I'd like to take the first part of that amendment first.
Representative Dowd moves to divide the amendment between lines 1.5 and 1.6. And he would like to vote on the first part of the amendment to the amendment first. That works. So if there's no more discussion of the first part of the amendment to the amendment, all those in favor, please say aye. Those opposed, please say no. The motion prevails. The first portion of the amendment to the amendment is adopted. On the second part of the amendment, Representative Dowd.
On the second part of the amendment, the author of the amendment to the amendment and I would both ask you to vote against this portion. We're going to strip this out. We're going to send it with just that one additional word into conference with an agreement between us to work on it to come up with a little fuller language in conference committee. So we'd ask you to vote against this second part of that amendment.
On the second portion of the amendment, all those in favor, please say aye. All those opposed, please say no. The motion does not prevail. The second portion of the amendment to the amendment is not adopted. We are now on the Dowd underlying amendment as amended by the first portion of the amendment to the amendment. Representative Dowd.
And we just ask for a yes vote to send the amendment as amended into conference. Thank you.
All those in favor of the Dowd amendment, please say aye. Those opposed, please say no. The motion prevails. The amendment is adopted. There is an amendment at the desk. The clerk will report the amendment.
Whitty moves to amend Senate File Number 2909, the unofficial engrossment as amended. The amendment is coded A31.
The member from Dakota, Representative Whitty.
Thank you, Madam Chair. The A31 amendment redirects money from unaccountable nonprofits and violence interpreters and instead gives it to our law enforcement to combat violent crime. $20 million goes to violent crime enforcement teams. $60 million goes to local law enforcement agencies to combat violent crimes, including gang and drug trafficking, carjackings, murders, and assaults. And $20 million goes to the State Patrol for the air patrol assistance in combating violent crime. There's a significant increase in violent crime. Being a former team lead of the street crimes unit in Burnsville, I've seen the need how the local, being able to use that money and run a unit and deal with the crimes that are important in your communities and try to combat it at a local level. Also, that State Patrol helicopter is utilized by all of our communities. So I would encourage a yes vote. Thank you.
I recognize the Representative Moller.
Thank you, Madam Speaker. So I'm going to recommend a no vote on this. Again, this is one of those amendments that is defunding violence prevention, meaning you're defunding the ability of local governments to apply for violence prevention grants. You're defunding the ability for victim services programs to apply for these grants in order to fund this. I'll say that our bill also has House File 25 in it, Representative Frazier's bill, to address the very issue of violent crimes in communities where they're having issues with violent crimes. The BCA is doing that work. Our bill puts $75 million into the BCA to help these local jurisdictions address those crimes, so we are already doing that. What this amendment does is putting this into an area that's really right now covering only drug crimes, so there's a concern that this was just a drug task force. And then I'll also say for the State Patrol, the State Patrol isn't within the jurisdiction of the Public Safety Committee. That's something that's in the Transportation Committee. We did fund the State Patrol's request related to a helicopter in that. It's my understanding that the Transportation Bill funded the governor's request, so we already did that in that bill. And for all those reasons, again, I'd recommend a no vote.
Any further? I recognize Representative Whitty.
Thank you, Madam Chair. I appreciate that, Ms. Chair Moller, and I do request a roll call.
A roll call being requested. With 15 hands, there will be a roll call. Representative Whitty.
Thank you, and I would ask for your support so we can serve our local communities. Thank you.
Any further discussion to the amendment? Seeing none, the clerk will take the roll. The clerk will close the roll. There being 68 nays and 62 yeas, the amendment does not prevail. There's an amendment at the desk. The clerk will report the amendment.
Novotny moves to amend Senate File Number 2909, the unofficial engrossment as amended. The amendment is coded A30.
I recognize Representative Novotny.
Thank you, Speaker. My amendment A30 would take $100 million out of the funding and put that towards the governor's proposal, which would distribute the money to the state of Minnesota based on population and some other formulas that would be increases where there is high crime. If we're really going to be one Minnesota, I think that we are all in this. All of Minnesota has seen an increase in crime in the last couple of years, and I think that everyone, all these communities across the state could use a shot in the arm and help with some of this one-time money. So I hope that you agree with me and the governor on this. I think that we've seen enough of the nonprofits that we don't know about that will be applying to this, and I think it would be better, for example, under the proposal, I believe Minneapolis would receive $25, $30 million. Now, obviously, that money is not going to be used just for policing. They couldn't hire enough cops to spend that money if they wanted. The city of Minneapolis would then allocate that money through their resources, and they know who are the groups that are good and will use the money correctly. And if they see a problem with the work or what is being done, that they have the ability to change those programs and reallocate it where it will be best used. Madam Speaker, I will request a roll call vote.
A roll call being requested. Seeing 15 hands, there will be a roll call vote. Representative Novotny.
And I ask for a green vote. Thank you.
I recognize Representative Moller.
Thank you, Madam Speaker. I'm going to recommend a no vote on this one as well. The governor's proposal was actually a tax bill that wasn't referred to our committee. I carried the governor's bill, as is customary for the chair of the committee to do. This proposal wasn't in the public safety bill. What is in the public safety bill is a number of things for our local communities. We have victim services funding. We have recruitment for law enforcement. We have a mental health crisis response, first responder treatment for mental health, in our bill. Again, we have the probation formula that 87 counties like, and then importantly, the violence prevention funding, which again, this amendment tries to defund. And I'll just keep correcting what's being said about that particular provision. We have to have the nonprofits that apply to that. Again, local governments can apply, and nonprofits that apply have to have local government support for that. Again, if you're going to vote for that, you're going to be voting against what this violence prevention work is in our bill, and for all those reasons, I'd recommend a no vote.
Any further discussion? Representative Novotny.
Thank you, Speaker. My only counter would be that the bill 25, it always reminds me, I had a friend that worked in the insurance industry, and she told me that insurance, the big bold print giveth and the small print taketh away. And I believe that the same thing when every time I read the bill, we talk about where it is going to go, but if you read the fine print, it can go to a whole bunch of things like homelessness and nonprofits and violence interrupters. And I know that we're going to have a lot of money and other bills coming before us that'll go towards homelessness and other problems that we have. I'd like to see this go towards the whole state, not have it go towards specific nonprofits. And I ask again for the green vote. Thank you.
Seeing no further discussion, the clerk will take the roll. The clerk will close the roll. There being 66 nays and 65 yeas, the amendment does not prevail. There's an amendment at the desk. The clerk will report the amendment.
New Brindley moves to amend Senate File Number 2909, the unofficial engrossment as amended. The amendment is coded A19.
I recognize Representative New Brindley.
Thank you, Madam Speaker. The omnibus bill contains a provision on the Minnesota Rehabilitation and Reinvestment Act. The MRRA allows the Department of Corrections to release a prison inmate after serving only half their term of incarceration if they reach some certain benchmarks. Now, I want to be very clear, that is not half of the sentence that the court imposed. Because right now, they're only going to serve 2/3 of that sentence of what was imposed by the court. And so this language in the underlying bill would cut that in half. So we're talking about criminals serving 1/3 of the sentence imposed by the court. That's what's happening in this underlying language. Now, this is something that has come up in the past. We've dealt with this provision in the past, 2 years ago. But at least 2 years ago when we did this, the language excluded some violent crimes. The language was better than what is before us today. So what my amendment does is it goes back to that earlier version of the MRRA, and it excludes some very specific crimes to this. And I want to be clear on what those crimes are and why I think that we should probably exclude these violent crimes. So my belief, and I think that the belief of the chamber will be, that if you commit first-degree murder, this is murder that is premeditated, planned, intentional. It means you went out with the purpose of killing someone and did so. Premeditated murder, first-degree murder. I actually don't think you should be eligible to serve only 1/3 of your sentence. I think that you should serve your sentence if you commit first-degree murder. I also think that if you commit first-degree criminal sexual conduct, that you should serve your sentence. And let's be very clear on what we're talking about when we're talking about first-degree criminal sexual conduct. We're not talking about saying some words that someone doesn't like. We're not talking about groping in a public place. We are talking about rape. I'm going to use some words here that make people uncomfortable. First-degree criminal sexual conduct. We are talking about things like penetration. We are talking about sex crimes that involve children. First-degree criminal sexual conduct includes force. It includes weapons. It applies when the victim is mentally impaired or mentally incapacitated or physically helpless. This would include crimes of pedophilia. And I actually think that somebody who is convicted of first-degree criminal sexual conduct should serve their time. And they should not be eligible for release after 1/3 of their sentence. And I'm going to go ahead and give you an example here that I find particularly horrific. Years ago, my mom worked in a nursing home in Robbinsdale, as a matter of fact. And this was a nursing home that was not limited to senior citizens. They had folks of all ages in that nursing home, and they took care of really the most medically complex, the most medically needy patients. And there was a young woman in their care who was effectively in a vegetative state. And one night, someone from staff entered her room as a male staff member was climbing off of her body and redressing himself. I do not think it is okay for that person to serve 1/3 of their sentence. That person should be forced to fulfill their sentence. My amendment would also exclude dangerous sex offenders where the court specifies a minimum term of imprisonment. This can be related to first-degree sexual conduct, but just understand that this is very rare. Courts do not do this often. Courts only impose these minimum terms of imprisonment in extreme and extraordinary cases. This does not happen often. And so if a court, after hearing all of the evidence, chooses to impose this minimum term of imprisonment, we should assume that there is good reason for that. and that person should be forced to fulfill their sentence and not serve just a third of their sentence. Members, please, please, please understand that my amendment does not apply to run-of-the-mill crimes. This does not apply to low-level offenses. This doesn't even apply to other murder or other criminal sexual conduct. My amendment only applies to the most heinous, most purposeful crimes committed in this state. And I would ask for a yes vote.
There is an amendment to the amendment. The clerk will report the amendment.
Moller moves to amend the New Brindley Amendment to Senate File Number 2909, the unofficial engrossment as amended. The amendment to the amendment is coded A44.
Representative Becker-Finn.
Thank you, Madam Speaker. 40A and 40B, we're not too far away. Members, the A44 amendment, sort of recognizing, some of the points that were made about the seriousness of these crimes, would direct the commissioner to work with victims groups, law enforcement groups, and faith-based organizations to consult whether these crimes should be treated differently. And just to speak to the MRRA in general, the reality is this. 95% of the people who are incarcerated will eventually return to our communities. And second, the status quo needs improvement. If solely locking people up for longer made us safer, we would be the safest country in the world. The MRRA, the Minnesota Rehabilitation and Reinvestment Act, is transformational by design. It is a big change, but a big change is needed. It is an incentive program. It is earned incentive release that maintains public safety at a reduced cost and is good for everybody in our communities. So there would be meaningful engagement of education programs, workforce trainings, addiction treatment. There would be individualized programming to make sure that people who are incarcerated have meaningful opportunities to rehabilitate, to correct. So that is what the MRRA does. And again, this amendment to the amendment recognizes the seriousness of the crimes, but we want to have the commissioner determine that with those community groups that were mentioned, including victims groups. Thank you.
Representative New Brindley.
Thank you, Madam Speaker. I would argue that what the A44 amendment does is actually abdicate our responsibility as legislators. It doesn't recognize the seriousness of the crimes. If we were going to recognize the seriousness of the crimes, we would just say right here, yes, of course. Of course, people who commit this level of heinous crime should serve their sentence. But instead, the Democrats in the House tonight are going to abdicate that responsibility. They're going to say, no, we don't want to take that vote. It's a hard vote, and I get it. It's a hard vote. But that's what we're doing. We are abdicating our responsibility. We are saying that, well, we don't want to say out loud right here that we don't want to change this language. We don't want to exempt these crimes. Instead, we're going to pass the buck. We're going to let some unelected bureaucracy decide instead who can hide behind their positions and not have to answer to the people. Well, I'm happy to answer to my constituents. I am happy to tell my constituents right here tonight that I think that people who commit these crimes should serve their prison sentences. I am happy to tell my constituents tonight that it is unacceptable for someone who is convicted of rape to serve just 1/3 of their sentence. It is unacceptable for someone who plans and executes a murder to serve just 1/3 of their sentence. It's not right. It's not right. Madam Speaker, I would request a roll call on the Moller amendment.
Representative New Brindley requests a roll call. Seeing 15 hands, there will be a roll call.
Thank you. And members, I would encourage a no vote on the Moller amendment.
The member from Isanti, Representative Johnson.
Madam Speaker, members, we have election certificates, so we have to make the hard decisions. Thank you, Representative New Brindley, for your words. We have done enough sending our responsibility to the other end of the hallway to the executive branch. If you can't make the decision, the door is there, you can leave. This needs to be done by the legislature. It's absolutely ridiculous, absolutely bonkers that we'd even consider changing our responsibilities to somebody else. I'm ashamed of this body right now. Vote no on this amendment.
The clerk will take the roll on the amendment to the Representative Scott.
Thank you, Mr. Speaker, or Madam Speaker. I thought you saw me when we were raising our hands, but maybe not. Thought I made eye contact. Representative New Brindley, thank you for bringing this amendment. I can't believe you have to bring an amendment like this. Why weren't these crimes carved out in the first place? That is astounding to me. Members, I've done a lot of talking in the last few years about the fact that, just talking about the downward departures in felony convictions in the state of Minnesota. And the data came from the Sentencing Guidelines Commission, which is another example of where we've abdicated our responsibilities here in the legislature by giving them that authority. But nonetheless, they found that just in felony cases, that in 40% of those cases where prison or jail time should have been the sentence, that those were 40% of the time, those were downwardly departed and people never served a day. Felonies. And now we have the trend continuing, even worse, where someone that's convicted of first-degree murder or first-degree criminal sexual assault serves 1/3 of their sentence? What are we doing here? Do we want safe neighborhoods or not? And this amendment to the amendment is very well said, Representative Johnson. We're abdicating our responsibility again, and it's just going to do nothing but further make our communities less safe. Please vote against the A44.
The clerk will take the roll on the amendment to the amendment. The clerk will close the roll. There being 70 ayes and 61 nays, the motion prevails. The amendment to the amendment is adopted. We are on the underlying New Brindley amendment. Representative New Brindley.
This is really unfortunate. Frankly, the underlying amendment is pretty meaningless at this point. But I suppose it at least lets someone exercise some sanity and say that folks who commit these crimes should have to serve their sentences. So I suppose I would still ask for a yes vote on the underlying amendment. I'm not going to withdraw it. And I am going to hope, beg, plead that there will be some sanity from the folks who will now have the authority to look at this and make a determination that these crimes should absolutely be excluded from this. And that there are some crimes for which people should actually have to serve their sentences. Thank you, Madam Speaker.
Any further discussion? All those in favor of the amendment as amended, please say aye. Those opposed, please say no. The motion prevails. The amendment is adopted. There is an amendment at the desk. The clerk will report the amendment.
Niska moves to amend Senate File Number 2909, the unofficial engrossment as amended. The amendment is coded A22.
The member from Anoka, Representative Niska.
Thank you, Madam Speaker and members. This amendment is about the provision in the public safety omnibus provisions that is a controversial provision allowing someone, other people, to petition the court to take away a person's Second Amendment rights to possess arms. The we have a number of concerns with this, but a lot of them have to do with due process as it relates to that important individual right. And in particular, the bill does not specifically provide any right to counsel whatsoever in that extreme risk protection order hearing. So the A22 amendment simply provides a right to counsel, very similar to rights to counsel that we have in other places out in the Judiciary Committee. And in this omnibus bill, we have a number of places where we recognize the importance of the due process right that someone has a right to counsel. We're funding public defenders. Very early on, one of the first votes I took in this session was a unanimous vote for us all to fund the Board of Public Defense, and we're funding it again in this Public Safety and Judiciary Omnibus Bill. We're also funding civil legal services, and we're funding a new Office of Appellate Counsel for Parents. Representative Becker-Finn brought that bill before our committee, and I think it does some important things in terms of helping parents in child custody cases to be able to have due process rights by having a right to counsel. Our current law has a provision that allows for right to counsel in civil commitment proceedings. We'll talk a lot about how compare and contrast these extreme risk protection order proceedings to civil commitment proceedings. I'm personally of the opinion that that's probably a better way of dealing with a lot of these circumstances than this new extreme risk protection order situation. But the right to counsel language in my A22 amendment is taken directly from the civil commitment statute. So if we're giving the right to counsel when someone's liberty is being potentially at jeopardy in the right to counsel, or in a civil commitment, we should be giving them the same right to counsel in a extreme risk protection order context where we're trying to take away their constitutional Second Amendment rights. So members, I hope that this is seen as a friendly amendment, and so I ask for your support on the A22.
There is an amendment to the amendment. The clerk will report the amendment.
Becker-Finn moves to amend the Niska amendment to Senate File Number 2909, the unofficial engrossment as amended. The amendment is coded A47.
Representative Becker-Finn.
Thank you, Madam Speaker. So this would change the language from shall to may. The underlying amendment as drafted may actually be out of order. As we know, there is a cost to providing counsel. That's the bulk of the judiciary budget is on paying attorneys. I'm guessing the other attorneys in this body also charge a fee for their services as well. So we're changing this from a shall to a may. The only, you don't even have a right to counsel when you're getting an order for protection or trying to keep your housing. We certainly don't need to have a right to counsel in this incident, but people are certainly welcome to have attorneys if they would like.
Representative Niska.
Thank you, Madam Speaker, and Representative Becker-Finn. I'm disappointed that we're I agree with a lot of the provisions you have brought forward in the Judiciary Committee about the importance of counsel. And again, if we're talking about a constitutional right here, then we should be talking about the right to counsel when the government is trying to take it away. That's why we have a right to counsel in civil commitment, and we should have a right to counsel here. And make no mistake, the Becker-Finn amendment to the amendment guts that right to counsel. It eliminates the word right, and it eliminates anything about the court appointing counsel. There's a reason why the courts appoint counsel in civil commitment cases. It's because it's a serious thing where we're dealing with someone's liberty. Well, this is a serious thing where we're dealing with someone's liberty. And if you're voting for the Becker-Finn amendment, then you're voting that this isn't a serious right where we're dealing with someone's liberty and we need due process. So, Madam Speaker, I request a roll call.
Representative Niska requests a roll call. Seeing 15 hands, there will be a roll call. Representative Niska.
Thank you, Madam Speaker. Members, it's pretty simple. Are we talking about an important right here or not? Are we talking about due process here or not? If we're talking about due process, then vote no on the Becker-Finn amendment.
Representative Quam.
Thank you, Madam Speaker, and I am really confused because when we get to the point where we're deciding when a person has a right to counsel, to protect their rights, when government is involved, and sometimes they have a right to a counsel, and other times they don't, that's an abuse of government. If it's a right and it's appropriate that they have a counsel, then they should have a counsel. And I don't even understand why we're trying to deny this. I thought we were in America.
Seeing no further discussion, the clerk will take the roll on the amendment to the amendment. The clerk will close the roll. There being 67 ayes and 63 nays, the motion prevails. The amendment is adopted. We are on the underlying Niska amendment as amended. Representative Niska.
Thank you, Madam Speaker and members. Well, I'm extremely confused about what we're doing in this overall bill. We have an Office of Appellate Counsel because we have said that when the state comes and tries to take your kids away, that's something that you have a right to counsel for. When the state comes and tries to prosecute you for a crime, that's something you have the right to counsel for. But apparently we've decided that the Second Amendment is a second-class right, that it's not a constitutional right that you really get due process for, that you really get the right to counsel for. The amendment as amended is worthless. And so, Madam Speaker, I withdraw the amendment.
Representative Niska withdraws the 822 amendment. There is an amendment at the desk. The clerk will report the amendment.
Hudson moves to amend Senate File Number 2909, the unofficial engrossment as amended. The amendment is coded A28.
Representative Hudson.
Thank you, Madam Speaker.
That's not the one, is it? No.
Members, it often goes unemphasized, not entirely unsaid, but certainly unemphasized, that we have a crisis when it comes to the recruitment and retention of our peace officers in the state of Minnesota. And, you know, one of the qualities that your average peace officer has that I envy is the ability to just stoically take abuse, to just take it and move forward, stay unmoved, stone-like, professional. That quality is demonstrated on a daily basis by our peace officers. And one of the ways in which it's demonstrated is as they stand by and show no reaction whatsoever to the debates that they hear us have about provisions that are going to have a very profound impact upon their quality of life and even up to and including their safety and their ability to protect themselves. And, you know, that debate, the debate we've had about the role of law enforcement officers in our society has had a profound impact in recent years. What the 828 amendment does, just to cut to the chase, and then I'll give some background, is it increases the penalty for assaulting a peace officer from its current status as a gross misdemeanor to a felony. And the rationale for doing that is we've seen an alarming uptick in the number of assaults on peace officers in recent years. You go back to 2019, and the BCA Uniform Crime Report noted that there were 467 peace officer assaults statewide, which that number just onto itself is fairly alarming. But more alarming is the fact that over the next few years, those numbers jumped to 1,112 in 2001, and that was a 140% increase over a 3-year time frame. Now, we had some robust conversation in the Public Safety Committee regarding events and rhetoric which may have contributed to that 140% increase in assaults on peace officers. But certainly, regardless of what you want to attribute it to, this is an alarming uptick and it needs to be dealt with. And we need to send the signal. We need to send 2 signals. One, that this is unacceptable behavior that is going to come along with it meaningful, lasting consequence. And 2, and I think perhaps even more importantly, we need to signal to these men and women who are willing to put on a badge and take on the public trust and represent us, enforce the laws that we write, go out there and do the things that we tell them to do, that we actually honor them for that, and that we value them for that, and that they're important, and that they're worthy of protection, that as they protect us, they're worthy of being protected by the laws that we write. That's the intention behind this. Nine peace officers were shot and 3 killed in Minnesota and western Wisconsin since January 23rd of this year. This is a problem. And I've got a really good way to pay for it in this bill in order to cover the cost of additional prison beds resulting from the increased penalty. We're going to shift some money from the appropriation that currently is allocated towards reducing the fees prison inmates pay for communications with the outside world. I think they can talk to their friends outside a little bit less. That's a pretty light price to pay to ensure that we protect the people who protect us. I hope this will be accepted as a friendly amendment, and I ask for your green vote.
There is an amendment to the amendment. The clerk will report the amendment.
Moller moves to amend the Hudson Amendment to Senate File Number 2909, the unofficial engrossment as amended. The amendment is coded A39.
Representative Moller.
Thank you, Madam Speaker. And there is no doubt that police officers have incredibly difficult jobs. There also is no doubt that recruitment of law enforcement in our state is also an issue, and that's why our bill addresses that. That's why Representative Hewitt worked very closely with law enforcement groups in order to get that language drafted that is in our bill. What I'll say about this particular amendment and for the amendment to the amendment is that if you look at the underlying language of the primary amendment, currently in statute, it is already a felony to physically assault an officer if the assault inflicts bodily harm. And what people may not realize is that bodily harm is separately defined elsewhere in statute, and it means physical pain or injury, illness, or any impairment of a physical condition. So any assault that causes pain, injury, illness, or impairment of a physical condition already is a felony. I'm going to say that one more time. Any assault against an officer that causes physical pain or injury, illness, or any impairment of a physical condition already is a felony. And so what our amendment does is it goes back to the gross misdemeanor language, but does say that a second or subsequent offense for just an assault that doesn't cause any pain, physical impairment, or injury would be a felony, but that first offense would not be. So for that reason, members, I recommend a yes vote on the A39.
Any discussion to the amendment to the amendment? Representative Hudson.
Thank you, Madam Speaker, and thank you, Chair Moller. I was looking forward to learning what the rationale for your amendment to the amendment was going to be, and it is indeed very interesting. I would say that asking our law enforcement officers to have to endure assault to the extent that they have. Again, a 140% increase in just a 3-year period of time is not something we should have to ask of them. They do a fantastic job, as I noted, of being stoic, of rolling with the punches, figurative and literal, and being professional and showing up every day in spite of the fact that they know a large segment of their community outwardly despises them. I saw it myself on a ride-along with MPD just a few weeks ago, showing up to a scene where just because they were there, they were enduring taunts and insults and things that I can't repeat here on the House floor. And they endured it stoically, professionally, with a smile, with an eagerness to serve. And that's their job. We expect that of them. I don't think we should expect them to have to endure a 140% increase in assaults over the course of 3 years. I don't think that's something we should have to ask them to do. So I'm going to ask folks to vote no on this amendment to the amendment. I think we need to send a strong signal of support for our law enforcement officers and a strong signal towards those who would assault them that that behavior is not going to be accepted, even if it fails to cause great bodily harm. And I would ask for a roll call vote. Madam
Representative Hudson requests a roll call. Seeing 15 hands, there will be a roll call. Representative Quam.
Thank you, Madam Speaker. And frankly, intent should matter. Just because somebody was not competent enough to really hurt somebody doesn't mean that if they're assaulting and attacking, that's okay. Oh, we'll just slap your wrists. Better luck next time. Maybe you can, hurt them. So the intent of attacking a police officer and it being trivial, I think is wrong, because we don't hear all the cases where they've saved lives, where they have put themselves in danger. Apparently society judges you have the worst cases and you're all stereotyped and prejudiced because of the worst cases. We need to look at the best cases and what happens when they're not there. And the intent to assault just because you weren't comparable or capable or whatever to really do any damage doesn't make it less offensive, because they're to serve and help, and they deserve not to be attacked.
Representative Moller.
Thank you, Madam Speaker. I need to correct a couple things that have been said on the floor. One thing that the author of the primary amendment said, even if it fails great bodily harm is also defined in statute. There are different levels of harm defined in statutes. Bodily harm, there's substantial harm, there's great bodily harm. Bodily harm that's currently in our statute as a felony is the lowest level of harm. Pain, but the stuff I read earlier, the physical impairment of a physical condition, pain, that is a very low level of harm. And our assault statutes are not based on intent, they're based on the level of harm. Whether you're first through whatever degree of assault, it all depends on the amount of harm you caused. And so that's what we're talking about here. I also wanted to just comment on the prisoner phone calls as taking away money from that. That is really important for rehabilitation, for folks who are incarcerated, but I'll also tell you that it serves a prosecution purpose. I have had cases where I've listened to those calls. They are recorded, and they've actually helped us in our cases solve some of those cases. So it's really important. We're doing it because we really recognize how that's important to rehabilitation for folks, but I'll tell you that having phone calls that are recorded can aid in prosecution. Thank you, Madam Speaker.
The member from Isanti, Representative Johnson.
Madam Speaker, Representative Moller, I'm disappointed. We've heard time after time in committee, and even on this House floor, that we had to increase civil penalties to make sure people follow our law. No peace officer should be assaulted. No person should be assaulted. Representative Hudson, thank you for increasing this penalty. I myself have been assaulted many times. Usually the perpetrator doesn't get anything because some judges call it part of your job. We need to do what we can to protect the few officers we have left. I'm not sure how many hundreds Minneapolis is down. We're somewhere down between 12 and 1,500 officers across this state. And it's going to take many years to get them back. We need to protect the ones we have, making sure that those that assault them are dealt with, because if they assault a peace officer, they'll assault you. Making it a second offense is, hate to use the word again, but bonkers. Let's start backing our law enforcement officers. And by doing that is making it sure, doing what we can to keep them from getting assaulted so they can do their job to protect you and me. Vote no on this amendment.
The clerk will take the roll on the amendment to the amendment. The clerk will close the roll. There being 68 ayes and 62 nays, the motion prevails. The amendment to the amendment is adopted. We are on the underlying Hudson amendment. Representative Hudson.
Thank you, Madam Speaker, and thank you, Chair Moller. In spite of the fact that I don't agree with your amendment to my amendment, I appreciate the fact that you're at some level embracing the underlying premise that we need to do something to protect our law enforcement officers. Thank you, Representative Johnson, for standing up. I didn't expect that, and it's meaningful because he's a former law enforcement officer. We got a few of those in this chamber on both sides of the aisle, and I am not one, and yet I'm offering this, and I think that that's significant because it is those of us who don't serve in that role who are represented by those who do. And the bit you said, Representative Johnson, about if they're willing to assault you, they're going to be willing to assault me. Yeah, absolutely. And that's why we should do this. That's why we should have a higher threshold, a higher standard. We often talk about a higher standard for police officers. They should be held to a higher standard, which is true, they should be. But how about lifting them up to a higher standard, providing a higher degree of consequence for assaulting them as they are representatives in a meaningful way of us? So I'm going to go ahead, even though it's been neutered a bit, it still takes us in the right direction, so I'm going to recommend a green vote, and I'm going to request a roll call. Thank you.
Representative Hudson requests a roll call. Seeing 15 hands, there will be a roll call. Discussion. Representative Moller.
Thank you, Madam Speaker. I'm going to recommend a yes vote on this amendment as amended. Thank you.
Any further discussion? Seeing none, the clerk will take the roll on the amendment. The clerk will close the roll. There being 120 ayes and 9 nays, the amendment is adopted. Or the motion prevails, the amendment is adopted. There's an amendment at the desk. The clerk will report the amendment.
Johnson moves to amend Senate File Number 2909, the unofficial engrossment as amended. The amendment is coded A14.
Representative Johnson.
Madam Speaker, members, the A14 amendment deals with the red flag laws. What it does is if a person knowingly and with intent gives false information to harass, abuse, or threaten is increased to a felony from a gross misdemeanor. Now, in Representative Pinto's House File 14, that puts additional restrictions on the transfer of firearms, making it a felony as well. So I feel it's only fair that if you're going to restrict somebody's firearms falsely and with intent to harass or abuse, it should be a felony as well. Because we're talking about somebody's constitutional right. With that, I would ask for a yes vote on the amendment.
There's an amendment to the amendment. The clerk will report the amendment.
Moller moves to amend the Johnson amendment to Senate File Number 2909, the unofficial engrossment as amended. The amendment to the amendment is coded A43.
Representative Moller.
Thank you, Madam Speaker. And this amendment is similar to what we did in the last one, where we say it's a gross misdemeanor here, but if it's a second or subsequent violation, it would be a felony. And I'd like to explain why we have gross misdemeanor in the bill language. For a permit to carry, it's a gross misdemeanor to give false information to the police, so we are consistent in our bill with that. I would also note a false report to police. If you report a crime is committed and you know that it's a false report and you intend the officer to act in reliance on that, that's actually only a misdemeanor. And a second or subsequent offense in that case is a gross misdemeanor. So we think this strikes the right balance, where this is a gross misdemeanor, but a second or subsequent violation then would be a felony. And I'm going to recommend a yes vote on the A43.
Discussion on the A43. Representative Johnson.
Madam Speaker, Representative Moller, I understand where you're coming from, but there's a difference here. This is restricting a constitutional right, a God-given right for us to keep and bear arms. It's actually in the Bible if you look for it. Now, you did this with the other bill. I'm hoping when you get to, you also have this bill for House File 14 that's later in the bill to make it gross misdemeanor and for the first offense and not to a felony for our law-abiding citizens, but I don't believe there's one there. This amendment actually makes it disappointing. You have no problems making it a second offense for assaulting a peace officer, but want to make it a felony to harass and remove somebody's Second Amendment rights. Vote no again on this amendment.
All those in favor of the amendment to the amendment, please say aye. Those opposed, please say no. No. The motion prevails. The amendment to the amendment is adopted. On the underlying Johnson amendment, Representative Johnson.
Madam Speaker, members, even though the first time they do that, it's the gross misdemeanor, at least it's a felony on the second time. Vote yes.
Discussion. Representative Moller.
Thank you, Madam Speaker. I'll recommend a yes vote on that.
All those in favor of the Johnson amendment, please say aye. Those opposed, please say no. The motion prevails. The amendment is adopted. There's an amendment at the desk. The clerk will report the amendment.
O'Neill moves to amend Senate File Number 2909, the unofficial engrossment as amended. The amendment is coded A26.
The member from Wright, Representative O'Neill.
Thank you, Madam Speaker and members. Yes, it is getting late. Members, about 5 years ago, almost, I moved into this beautiful home built in 1904 in the heart of Maple Lake. It's a beautiful little town, very friendly, very Catholic. In fact, the church is just a half a block away, and I get to hear the bells all the time, so it's really kind of fun. After I moved in, I got to meet my neighbors. Some of them were fantastic. Some of them kind of scared me. That's a story for another day. The neighbors very close to me became very near and dear to me. I'm going to change their names just to protect their privacy. So today we're going to call them Ron and Patty. And when I would leave my house out my back door and head to my car, because it's one of those 1904 houses, and the garage is not attached, and so I'd have to walk through the backyard to the car and go on my way. And Ron would sit in his back. He was retired. Patty went to work. And Ron would sit there and he'd shout out different things to me here and there and, you know, make small talk. And Patty was this amazing, big, bubbly personality, and they had a dog as a child, you know, those people that have dogs as children. And so we got to know each other and shared time together, and I just really valued their friendship and that they were fantastic neighbors. Pandemic hit, we all left. We all went home and tried to do Zoom and all kinds of things. You remember going through all of that? Not our freshmen didn't go through that, but it was really difficult. And I remember it was a spring day, it was sunny, it was beautiful out, and I was standing out on my porch on the front. And all of a sudden I hear this screaming and wailing. And Patty was just screaming out. And here comes law enforcement, and here comes paramedics, and on and on and on. And I ran out to see what was going on. And I could see her talking to law enforcement and couldn't hear exactly what they were saying, but I instantly knew. I knew that Ron had taken his life. So I went over to the side of her yard, hugged her across her fence, spent a little bit of time with her, and she said, "Marion, I didn't know. I went to work." And he had been stockpiling his medicine. And she goes, "It had to have been right after I left for work that he took them." And she was just devastated. This wasn't the first time I had a neighbor that committed suicide. Just a few years before that, Dwayne, I lived in a duplex at that time, and Dwayne was on the other side of the duplex. He was a Native American man, and he was beautiful and kind and compassionate. But Dwayne was also incredibly lonely. And he felt like an outcast, is how he put it, in his own family. And one day, I went to a certain senator's house for the weekend, and Dwayne knew I was there. And he went into the garage that we shared. It was divided by a wall. And he found something and a ladder. And Dwayne took his own life. Now, why am I telling you these stories? They didn't end their lives with firearms. They didn't. But they were as deep in a hole as one could be, and they were successful. And if someone gets to that point in their life, and require something like this in this bill. We're adding to this bill, we're adding to state law, an extreme risk protection order. And if that had been in place when these two men were in their dire, darkest days, I don't know if they had any weapons. I don't know. I wasn't even aware that they were in that deep, dark place. They kept it all deep inside. Ron's wife didn't know that he was in that deep, dark place. But here's my point, and this is what my amendment does. It says that if someone does know, and they know that that person has firearms in their house, and goes to the court and says, I think they're going to commit suicide, and they have firearms, and the order is granted by the judge, so they're certain that this is a real risk, and that sheriff or deputy or law enforcement officer comes to their home to remove those weapons, those guns, rifles, shotguns, pistols. You are still leaving that person at risk. You are still leaving someone that is in a deep, dark hole with plenty of other options, two of which I just described that I literally experienced with people that I love and cared about right next to me. They didn't have weapons, they didn't need them, they found other ways. If you leave that person in that home with all kinds of options to end their life, and all you do is take the weapons, you are not going to save them. So what my amendment does is says, if the court says that yes, they are at so much risk for suicide that we must take these weapons away, that you must then put them on a 72-hour psychiatric hold and evaluate them and get them help. You must. You cannot leave them in this deep, dark place to suffer and to die. You could take the weapons away and they will find another way. So, Madam Speaker and members, that is my amendment. Thank you.
There is an amendment to the amendment. The clerk will report the amendment.
Moller moves to amend the O'Neill amendment to Senate File number 2909, the unofficial engrossment as amended. The amendment to the amendment is coded A46.
Representative O'Neill. Representative Moller.
Thank you, Madam Speaker. O'Neill is actually my maiden name. So anyway, thank you, Representative O'Neill, for bringing this amendment. We do have this amendment to the amendment because I think it is important that mental health information and resources be made available in these situations, and then officers can assess if a 72-hour hold would be appropriate in this situation. So what our amendment does is it says that in this situation, they have to provide information about relevant mental health services in their area. And then, of course, if a 72-hour hold is appropriate, they can go ahead and do that. So I would recommend that members vote yes on the A46. Thank you.
Representative O'Neill.
Thank you, Madam Speaker. You got it.
My brain stops working at 9 p.m. Representative O'Neill.
Thank you, Madam Speaker. I know we're all running on fumes. Thank you. Members, you know, I appreciate that, Representative Moller, and I understand what you're trying to do, but this is so important that if this situation is so incredibly dire that we must literally pit that against our Second Amendment rights, our constitutional rights, it's so dire that they are imminently going to commit suicide or harm someone else. So we must take these weapons away. We must evaluate them to bring them to a 72-hour hold to get them evaluated. So members, I'm going to ask for a roll call on the amendment to the amendment.
Representative O'Neill requests a roll call. Seeing 15 hands, there will be a roll call. Representative O'Neill.
Thank you, Madam Speaker. And members, I'm going to ask you to vote no. And part of the reason I'm going to ask you to vote no on this is because my underlying amendment would be drastically changed, because what's so important is if this extreme risk protection order is so important to save someone's life, there are so many other options available to that person that they are still at risk. They are still at risk. They really need, if this is so dire, they absolutely must get some help. So I'm going to ask you to vote no on this amendment to the amendment so that we can keep the underlying amendment. Thank you, members.
The member from Olmsted, Representative Quam.
Thank you, Madam Speaker. And I just assumed that it was serious if they were going to be there. You don't hear, unless you're a neighbor or something. For over a decade, my wife was the head of the first responders in my area. And her pager would go off 2 in the morning, 3 in the morning, 10 o'clock. So I was able to hear the dispatch that came. And she couldn't tell me the details, but sometimes I heard in the paper. But frankly, you'd be amazed at the number of occurrences and issues along these lines of people that are suicidal. And I know for a fact that several were multiple calls and guns were taken away. And later there was another call and they were successful by other measures. And you don't hear about these much. I don't, but I can tell you that in a small town and 3 small townships, there aren't a lot of people, but there were a lot of calls. And that just if it's serious and a judge sees it's serious, it's serious. And that, frankly, these people, the persons that are hurting and are suicidal, they will find another way. And I can tell you that because it happened down in my area several occasions. And if it's serious, take it serious. Save a life. And go ahead and don't support this amendment, because I know people that have gone through a 72-hour hold, made it through, and they have good lives. They've got children, grandchildren, because the appropriate measures were taken for a serious situation. So please vote no on this amendment and help people.
The member from Traverse, Representative Becker.
Yeah, Madam Speaker, will Chair Moller yield to a question?
She will yield. Representative Becker.
In your amendment, it talks about providing the person mental health service information. Could you provide more detail? What would be provided, please? Thank you.
Representative Moller.
Thank you, Madam Speaker. Yes, similarly, when there's domestic violence information, law enforcement is supposed to provide information to domestic violence victims about resources available to those victims. So I'm thinking something similar that they could do in this situation, and I'm sure NAMI, National Alliance of Mental Illness, would be glad to help put together what that might look like. I will also say that we're doing so much for mental health and so many other bills. We're funding the 988 suicide hotline. That could be an example of something that would go in that card. A lot of other things are coming in the health bill and the commerce bills related to mental health. So I think something like that could be provided to the individual in this situation.
Representative Becker.
I appreciate that, Chair. On those type of scenarios, and I mean this respectfully, flyer or card with information is not enough. I've been on way too many runs that I don't even want to repeat that deals with suicide. Unfortunately, some that were successful of taking their lives. I remember one scenario, this person, don't know how she did it, but she drove down her driveway at 70 miles per hour, hit a tree, and she was in good shape when we showed up. So it was a Saturday night. Saturday nights are quite active. If you want to be an EMT, you want action, Saturday nights are it. So there was only 2 of us around, so I got in the back of the rig, and so we ran pretty quick to the hospital, and this gal could get out of anything. She wanted to jump out of the ambulance going 60, 70 miles per hour. Well, I told my driver to put on the brakes because she got out of the cot. We went all the way to the front of the ambulance together. We were a couple that time. And then my driver got around, and she got out, but we caught her. And the sheriff was behind us. Actually, it was a tribal PD. And they said, do you want us to take her? I said, yes, you can have her. And I share that story because she needed this type of help. Most individuals, the runs that I go on, and I mean this respectfully, don't need a piece of paper. They need help. They need more than information, because I don't want to come back again and respond to the same scene, because that won't be a taxi run. That will be, unfortunately, a death. So I agree with Representative O'Neill. She's spot on, and there are people that need that service, and that's what we're here, folks. So I know your intentions are good. I mean that sincerely. But a piece of paper won't do it. They need that 72-hour hold for their health, mental health, but also for their family members, just to slow down, bring the emotions down, and get them the help. Because I'm no mental health person, though they need the right service. So I would ask not to support Moller's amendment, Chair Moller's amendment. Thank you.
Seeing no further discussion, the clerk will take the roll on the Moller amendment to the amendment. The clerk will close the roll. There being 68 ayes and 62 nays, the motion prevails. The amendment to the amendment is adopted. We are on the underlying amendment. Representative O'Neill.
Thank you, Madam Speaker and members. It's very disappointing. I mean, if it's so severe that we have to go to the court and ask for their weapons, their guns, their Second Amendment rights to be taken from them, and they're about to commit suicide, they absolutely belong in a 72-hour hold to get help, to get a little pause in their life, to be fully evaluated. And so, members, I'm going to withdraw this amendment because it just isn't going to do enough to really help and protect these very, very vulnerable people.
Representative O'Neill withdraws the 826 amendment. There is an amendment at the desk. The clerk will report the amendment.
Grosso moves to amend Senate File Number 2909, the unofficial engrossment as amended. The amendment is coded A24.
The member from Clearwater, Representative Grossell.
Madam Speaker, members, the A24 amendment deletes the Law Enforcement Citizens Oversight Council section in the bill. This section gives civilian oversight councils the authority at the end of any criminal investigation or prosecution to investigate allegations of misconduct, to conduct its own investigations. Councils would have the power to subpoena or compel testimony on documents, make a finding, of misconduct and recommended discipline, impose discipline if the City Council gives the authority. Looking at this bill was proposed because of problems in Minneapolis. This is not a problem over other parts of the state. And the recent agreement between the Minneapolis Police and the Minnesota Department of Human Rights really shows that this provision really is not needed. A coverall for the state is not what is needed. Heard plenty of talk in committee where you have different programs, but it's not a one-size-fits-all. You let citizens in their communities do what fits their community. Communities already have the ability to put oversight committees in place. So this, to have it in statute is really not necessary. As far as the law enforcement community, we police their own very well. They do a very good job. If there's misconduct, if there's punishment that needs to be done, it's done. If there's criminal activity, they get prosecuted. So please accept my amendment as a friendly amendment. Thank you, Madam Speaker.
Discussion to the Grossell amendment. Representative Frazier.
Thank you, Madam Speaker. Representative Grosso, one of the things that you said is that it shouldn't be a one-size-fit-all, and this isn't a one-size-fit-all. In fact, back in 2012, under the Minnesota Peace Officer Discipline Procedure Act, this power was there for local jurisdictions, city councils to allow for these type of civilian oversights with that particular power. Took that power away in 2012. Fast forward to May 25th, 2020, and we had one member talk about it as an incident. It was the murder of an individual in broad daylight in the city of Minneapolis that was seen around the world that sparked a lot of what we're still dealing with today. These civilian oversight boards were meant to help develop trust between the community and law enforcement. That is still what they're meant to do. But we have taken power away from the local jurisdictions that know their jurisdictions, that can decide how they want to build those oversight boards and how they want to empower them and how they want them to work with their local police forces. They can do that. They don't have to develop a civilian oversight review board. They don't have to give them subpoena power. They don't have to do any of that. But it will allow those jurisdictions that know their jurisdictions, that know their residents, that know their constituents, that know their voters, know their neighbors, know their local law enforcement. It would allow them to do what they want to do, which is what is best. It would allow them to do what is best for their community. So I would urge a no vote on this. I would urge us to support our local jurisdictions, our local communities, allow them to decide and do what's best for their communities. And I think that is another tool that we need. I know we want to stop talking about what happened here in our state, what sparked a movement around the world. I know we want to stop talking about it, but it hasn't been that long. May 25th, 2020. It hasn't been that long. Hasn't been 3 years yet. And we are still showing the world what we're going to do as a state so that something like that doesn't happen again. And this is one of the tools that can help with that. Thank you.
The member from Sherburne, Representative Novotny.
Thank you, Speaker. I would request a roll call vote.
Representative Novotny requests a roll call. Seeing 15 hands, there will be a roll call. Representative Novotny.
Thank you, and I'd just like to address the last comment from Representative Frazier. With the changes that have come and the decisions that Minneapolis City Council has made, they've put these into works, and I anticipate that more will come down with the dissent decree that it's rumored to be coming. They've demonstrated that they can do this on their own and they don't need a state law, and we believe in local control. Thank you, Chair.
Seeing no further discussion, the clerk will take the roll on the Grossell amendment. The clerk will close the roll. There being 60 ayes and 68 nays, the motion does not prevail. The amendment is not adopted. There's an amendment at the desk. The clerk will report the amendment.
Niska moves to amend Senate File Number 2909, the unofficial engrossment as amended. The amendment is coded A21.
Representative Niska.
Thank you, Madam Speaker and members. Well, I haven't been real successful tonight, but I'm going to take one more swing at it. I'm pretty optimistic about this one, though. This amendment was inspired by Representative Frazier 2 weeks ago in the Commerce Committee. He was presenting, I think, pinch hitting for Representative Richardson, presenting House File 2. And he presented a new definition to House File 2, amended the definition of a family member. And I had heard some concerns about the way that family members are defined in the transfer restrictions here, that it's a little bit too restrictive. And I thought the way that it has now been amended into House File 2 was really a very comprehensive list of the types of close relationships that we're looking at when we're looking at trusted relationships that where you might care for somebody enough to want to take family leave for them or trust them and care for them enough to be able to transfer a firearm to them and be confident that that firearm transfer is something that should fit within the exclusion in our firearm transfer the firearm transfer provision in this bill. So I'm assuming that this was just an oversight, that this definition that was offered in House File 2 was not also offered in the same place in this bill. And so I'm offering this. Hopefully it's a friendly amendment. I hope you'll support the A21 amendment. Thank you.
Discussion. Representative Pinto.
Thank you, Madam Speaker. Representative Niska, thanks for presenting this proposal, the A21. Members, this allows the chance to highlight the fact that the criminal background check provision that's in this bill, one that makes sure that when there's a transfer of a firearm, that there is a criminal background check. We have that on many gun sales. We should have them on all gun sales, but with some exceptions. And there's a number of them in the bill, including when there's a transfer among immediate family members. Part of the reason for that is because you're going to know if an immediate family member has the kind of criminal conviction that would cause somebody to not be able to receive a firearm. That is not true in the list the Representative Niska has presented in the A21 amendment, which includes a number of folks, including one person simply designated by the transferor. It is a very different situation than that's referenced by Representative Niska, a situation where somebody is stepping away from their work and receiving a significantly lower pay in that House File 2 paid family leave situation. In this situation, we do want to make sure that if you're going to transfer a firearm to somebody else, that you absolutely would know what their criminal record is, and that we really are talking about that kind of immediate family situation. So I would urge members to vote down the A21. Thank you, Madam Speaker.
Representative Niska.
Thank you, Madam Speaker. And I'm sad, Representative Pinto. I thought you were going to take this. It is quite a nice list, I think, of exactly the kinds of people that someone, if they know and care and trust about them enough that, as you said, they would take less pay in order to care for them. That's exactly the type of close family relationship that we should be talking about in the exclusion for this. So members, I urge your support, and Madam Speaker, I request a roll call.
Representative Niska requests a roll call. Seeing 15 hands, there will be a roll call. Well, I didn't look, but I just assumed you produced 15 hands. Any further discussion? Seeing none, the clerk will take the roll on the amendment. The clerk will close the roll. Sorry. There being 62 ayes and 67 nays, the motion does not prevail. The amendment is not adopted. There is an amendment at the desk. The clerk will report the amendment.
Johnson moves to amend Senate File Number 2909, the unofficial engrossment as amended. The amendment is coded A23.
Representative Johnson.
Madam Speaker, members, the 823 amendment, what it does is it allows a person under an extreme risk protection order to have an evaluation done by an independent licensed mental health provider. This is the carrot on a stick. Unfortunately, you didn't take Representative O'Neill's amendment without stripping it to when somebody's in crisis to get them the help they need. What this amendment does is give them an opportunity to go in and find out if there is a problem. And if a mental health professional concludes that the person is no longer in significant danger to another person or risk of suicide by possessing a firearm, or it never was, the court must terminate the order. Currently, the bill doesn't require getting the person that the order is for, who is at risk, the help they need, or even to find out for sure if they actually need help. There's no mental health professionals, the way the bill is currently written, to verify that the order is needed and that the person is in crisis or that the person is getting the help they need. But again, this is an opportunity to get a carrot on a stick so they will go in on their own to get the help if they need it. Now, the professional might say he does need help and get them the help they need, or it might say there wasn't a problem to begin with and is no longer in crisis, and give that person to exercise his constitutional rights again. Now, why do I bring this forward? Over the years, I've served many, many harassment and domestic abuse restraining orders, well over 1,000. And unfortunately, there are a few that are done out of spite and to harass people, which I have a bad feeling occasionally this will be done with the red flag laws. So what this amendment gives an opportunity for the person to redeem themselves and prove that they are not in problem, and by allowing the mental health professional to evaluate them and make a recommendation to the courts. I do ask that you support this amendment, and I do request a roll call.
Representative Johnson requests a roll call. Seeing 15 hands, there will be a roll call. Discussion to the Johnson amendment. Representative Frazier.
Thank you, Madam Speaker. Representative Johnson, I understand what you're trying to do here, so I can appreciate that. The bill currently allows for an opportunity for an individual to petition to remove an order if one is put in place. And there is nothing to prevent that individual from going through an assessment like that and presenting that to the court to make that determination. My concern is, now there is a list from lines 242:17 all the way over to 243:33. It lists out what the determining factors the court has to look at to determine when to grant the actual order. In those factors, one of them is to consult with law enforcement. I mention that because that was a big deal for law enforcement when we had conversations. They wanted to make sure that they were consulted in situations like this to provide information to the court before they made a determination. What I don't want to do, and what I'm concerned that would happen with your amendment or your addition, is that you would take that ability away. You're essentially telling the court you can't consult any other sources to make a determination about whether this individual will commit harm to themselves or harm to someone else, and make a determination about whether or not to revoke or remove the emergency order. So I'm really concerned about that, and for that reason, I'm going to ask members to vote no on this amendment.
Any further discussion? Representative Johnson.
Madam Speaker, Representative Frazier, I'm disappointed. If you actually look at the amendment, this is after the order has already been served and in effect. Law enforcement officers are not psychologists, not mental health professionals. Judges are not psychologists or mental health professionals. Those are the ones that make that determination. Not law enforcement, not judges. They go by the information they receive from them. The way the bill is currently written, they're left out on the decision. The person that's supposed to be in crisis is not brought to get the help they need. This is the carrot on the stick if that person needs it to go get the help they need. Without this amendment, there is no carrot on a stick for that person to go get the help. Now you have an option. You can vote red and don't care about the person. Or you can vote green to give them an opportunity to get the help they need. The psychologist report might come back that they're in crisis and they need help. It might come back that never was in crisis. But without that opportunity and with that carrot on a stick to have that person go in to find out, we'll never know. You already stripped the amendment that would have required law enforcement to bring that person in to get help. So now we have to use the carrot on the stick. Please vote green.
Seeing no further discussion, the clerk will take the roll on the amendment. The clerk will close the roll. There being 62 ayes and 67 nays, the motion does not prevail. The amendment is not adopted. There is an amendment at the desk. The clerk will report the amendment.
Hudson moves to amend Senate File Number 2909, the unofficial engrossment as amended. The amendment is coded A1.
Representative Hudson, to your A1 amendment.
Thank you, Madam Speaker. So, members, we return to the concept of bias. This time we are talking about crimes. Last time we weren't. The omnibus contains a provision that expands the definition of crime motivated by bias in some of our criminal statutes. The list of those statutes refer to gross misdemeanor assaults motivated by bias, felony assaults motivated by bias, second and third degree criminal damage to property motivated by bias, along with harassment and stalking. And there is in existing law a lengthy list of protected classes that are inserted into that definition, things such as race, color, religion, so on and so forth. This bill is going to add ethnicity, it's going to add gender, gender identity, and gender expression to the list of biases that we're going to be taking into account when we're considering crimes. Now, personally, I don't understand and have never understood the underlying premise for increasing penalties based upon a perceived bias. If there is a crime that has taken place, then we should punish the crime. To add to our punishment of a crime based upon the thoughts that were motivating it, that is targeting the thoughts, which again is something we shouldn't be doing if we believe in free speech in the First Amendment, but we've already demonstrated here in this body tonight that that's just not where we're coming from, I guess. And so what I'm asking for here is something in the way of a compromise. Perhaps, perhaps my premise is if you can't beat them, join them. If we're going to say that we want to protect people who are disproportionately targeted for certain crimes for a variety of reasons that are motivated by bias, let's include a reason that has become increasingly prevalent in recent years. And that is political expression. I've got a piece right here, Mill City Times, relatively recent, March 4th of this year. Talks about a political organizer, or it's written by a political organizer who's reflecting upon an incident where an activist took things too far when they were upset by a city council member in Minneapolis who didn't vote the way that they wanted them to vote, and ended up acting out in an aggressive manner and assaulting and assailing her. We've heard accounts of Mayor Jacob Fry's house being under siege by folks who were upset with his policy. And efforts like this, and of course we've heard no end of rhetoric surrounding January 6th. And the idea there is that we recognize, I think rightly, that when you tack on, or when the motive of your assault or your harassment, your encroachment upon a person is to get them to do something politically, to change a vote, to shut their mouth, to go this way or that on an issue, that you've crossed a line. And we properly ought to recognize that as inappropriate. And so members, I hope this will be accepted. I hope if we're going to go with this premise that we ought to be punishing some crimes more than others, then we'll include in the list crimes that are motivated by bias due to someone's political expression. Thank you.
Discussion to the Hudson Amendment. Representative Becker-Finn.
Thank you, Madam Speaker. Political expression isn't defined anywhere in statute and isn't defined in this amendment. This would essentially be making a person's chosen political party a protected class. This is poorly drafted, it's bad policy, and we should vote it down.
Any further discussion? Representative Hudson.
I wouldn't think we'd need to define political expression. I think we all know what it is. And yeah, I think your identification, whether it's a political party or a political ideology or any sort of political expression, ought to be protected. In fact, that's what the First Amendment is there for. It doesn't get enforced uniformly, which is why it's a good idea to insert this provision. And especially in light of the debate we had earlier here tonight, where it was very explicitly stated that certain political expressions are being targeted for future government action, we know not what. But we know when you're aggregating data on speech you don't like for reasons that you won't define, that's a cause for concern. So I think if we're going to have that hanging out there in the air, it's deeply appropriate to take a proactive action to protect people from undue retaliation due to their First Amendment protected expression of political speech. I'll ask for a roll call vote, and I'll ask members to vote green.
Representative Hudson requests a roll call. Seeing 15 hands, there will be a roll call. The clerk will take the roll on the amendment. The clerk will close the roll. There being 61 ayes and 68 nays, the motion does not prevail. The amendment is not adopted. There is an amendment at the desk. The clerk will report the amendment.
Mueller moves to amend Senate File Number 2909, the unofficial engrossment as amended. The amendment is coded A18.
Representative Mueller.
Thank you, Madam Speaker. And thank you, members. Thank you, members, for this debate that we are having today. Our law enforcement deserve us to have this debate today. So thank you. So before I forget, Madam Speaker, I'd like to request a roll call on this amendment.
Representative Mueller requests a roll call. Seeing 15 hands, there will be a roll call. Representative Mueller.
Thank you so much, Madam Speaker. And members, my amendment is addressing a section from the bill in Article 11, Section 10, starting on line 180.16. It's a section that prohibits peace officers from affiliating with hate or extremist groups. The bill does a fairly decent job of defining what a hate or extremist group. It talks about how that a hate or extremist group means a group that has demonstrated by its official statements or principles, statements of its leaders or members, that its activities promote the use of threat, force, violence, or criminal activity, that it promotes seditious activities, and that it advocates for differences in the right to vote, speak, assemble, or maintain citizenship based on a person's perceived race, and it goes on forever. So this bill singles out peace officers. And my amendment, the A18, would add other licensed professions as under Chapter 214, including doctors, nurses, teachers, psychologists, marriage and family therapists, and lawyers. Now, members, when we think about the standard that we have asked our licensed professionals to obtain, making sure that they are not advocating or a part of any hate or extremist group is pretty important. And I think it's really good that we are going to put this expectation on our law enforcement. However, I think it's equally important for us to make sure that we're holding our other licensed professionals to the same standards. On March 30th, when we were marking up the omnibus bill, we offered this as an amendment, and several members on the majority party said that we could not accept this amendment because a police officer is a high calling. And with that high calling, it requires trust, accountability, and transparency. I want to say that again, members, because I'm literally, many of you who've had me in committee know that I take a lot of notes, and I try to the best of my ability to write down the reasons why we agree or disagree on something, because I honestly want to understand. I'm a visual learner, and I have to be able to write it down in order for me to remember and for me to really understand what you're saying. It's how I process. It literally was said in our committee that a peace officer should be held to this standard because we require that we have trust, accountability, and transparency. I cannot imagine a better description, a better expectation than of our teachers, our therapists, our doctors, and our lawyers, and then the other licensed professionals. We want and believe that we need to trust our teachers. We need to hold our teachers, our therapists, our doctors, our lawyers accountable. We need to make sure that they have transparency in what they're doing. And yes, we need to hold our law enforcement to that high standard. We should not tolerate any licensed professional in our state that promotes the use of threats, force, violence, or criminal activity. It is important for us to set high expectations and standards for all our licensed professionals, especially with those who work with our vulnerable populations. It is almost midnight. And those we trust to keep us safe, those who we trust to keep us physically whole, those we trust to keep us emotionally safe, emotionally healthy. all of those things. It would be a threat to not only our personhood, but to our actual being. If those type of professionals were a part of hate or extremist groups, that is the reason why we need to make sure we include all of the licensed professionals from Chapter 214. And members, I would ask that you would support my A18 amendment.
Point of order, Madam Speaker.
Representative Jordan, please state your point of order.
Madam Speaker, I rise to a point of order under House Rules 3.21. And Madam Speaker, under House Rules 3.21, motions and propositions must be germane. And a motion or proposition on a subject matter different from that under consideration, which is currently the Public Safety and Judiciary bill, must not be admitted under the guise of being an amendment, a motion, amendment, or other proposition offered to the House is out of order if it is not germane to the matter under consideration. As I said, this expands the scope of the bill. I think Representative Mueller talked about all the ways it would expand the scope of the bill. 214.003 is not in the bill, and I ask you to find this amendment out of order.
I find the point well taken. Representative Mueller.
Madam Speaker, I would like to request a roll call to
Appeal the ruling of the Speaker.
Thank you so much.
Representative Mueller appeals the ruling of the Speaker and requests a roll call. Seeing 15 hands, there will be a roll call. Representative Mueller.
I think if we're going to be, thank you, Madam Speaker, and I think if we're going to be honestly talking about this issue, and we're going to be holding the standards of all of our peace officers to this, it's funny, Madam Speaker, that this was not ruled out of order in committee.
There's no germaneness rules in committee. Representative Mueller.
And I think it's interesting, Madam Speaker, that while we are talking about this, that we need to make sure that we are willing to vote on this because we want to make sure to have high expectations to all of our professionals. Ladies and gentlemen, members, I would ask that we would make sure that we would vote red to overrule the ruling of the Speaker.
The clerk will take the roll on the appeal. The clerk will close the roll. There being 68 ayes and 61 nays, it is a judgment of the House that the ruling of the Speaker shall stand. Representative Long.
Madam Speaker, I move that Senate File number 2909 as amended be laid on the table.
Representative Long moves that Senate File 2909 be laid on the table. All those in favor, please say aye. Aye. Those opposed, please say no. The motion prevails. The file is laid on the table. The next bill on the calendar for the day is House File 447. The clerk will report the bill.
House File number 447. Number 4 on the calendar for the day, an act relating to civil law, the first engrossment.
Representative Long.
Madam Speaker, I move that House File number 447 be laid on the table.
Representative Long moves that House File 447 be laid on the table. All those in favor, please say aye. Aye. All those opposed, please say no. The motion prevails. The bill is also laid on the table. Announcements by the Speaker.
Announcement by the Speaker. Speaker announces the appointment of the following members of the House to a conference committee on House File 2335. Howard, Agbadje, and Johnson. Announcement by the Speaker. The Speaker announces the appointment of the following members of the House to a conference committee on House File number 2497. Joachim, Hill, Pryor, Clardy, and Creshaw.
Motions and resolutions. There's copies of the non-controversial motions at the House desk and online. If there is no objection, we will take action on these motions first. Hearing no objection, the motions prevail. Announcements. Representative Long.
Madam Speaker, I move that when the House adjourns today, it adjourns until 11 a.m. Wednesday, April 26, 2023.
Representative Long moves that when the House adjourns today, it adjourns until
11 a.m. Wednesday, April 26, 2023.
11 a.m. Wednesday, April 26, 2023. All those in favor, please say aye.
Aye.
All those opposed, please say no. The motion prevails. Representative Long.
Madam Speaker, I move that the House do now adjourn.
Representative Long moves that the House do now adjourn. All those in favor, please say aye. Those opposed, please say no. The motion prevails. The House stands adjourned until 11 a.m. Wednesday, April 26, 2023.